Morning.
Good morning all. We're here for an application hearing in the matter of CFI 018-2016 before His Excellency Justice Omar al-Muhairi. The claimant is represented by Clifford Chance, LLP, lead counsels James Abbott, assisting exchange jury. The defendants are represented by Squire Patton Boggs, lead counsels James Barrett, assisting as Adlan Farhad.
Yes.
Your Excellency, good morning.
Good morning.
Your Excellency, this is our application in relation to jurisdiction, but before starting, I regret I need to raise a matter of real concern with the court. Following the last hearing, Your Excellency, on the 10th of January, following which the court set aside the 2 default judgments which the claimant obtained, our firm learnt on Sunday that only last week the claimant has continued to take enforcement steps before the Dubai courts to continue to attempt to enforce these default judgments. Your Excellency will see in the hearing bundle, if I may very briefly take you at the end of it, the very last document at tab 23.
Court of Appeal application before Dubai court?
Correct, yes. Tab 23, page 221, Your Excellency.
Again, give me the tab.
Tab 23. It's at the back of the main revised hearing bundle.
Can you check the sound, please?
We have a spec of it.
No, I have it. No, I'm talking about the echo on the speaker.
Your Excellency will see there the Arabic is over the other page.
Let me find it first. And which bundle will be 3?
It will be in the main hearing bundle, Your Excellency. There.
Because the main hearing bundle is number 1 is nothing. Only the last tab is 20. I believe I saw that paper.
Yes. Your Excellency, that's how it hand up. This is the. No, this is the.
Actually, in tab 14.
Right.
Yeah, in tab 14. Yeah, I saw it.
Okay, I'm grateful. So, Your Excellency, the point essentially is that the claimant made a request on the 14th of May before the Dubai court in respect of the proposed enforcement against property in Sharjah. Now, Your Excellency, we say that in doing this, the claimant is disobeying the order of this court on the 21st of January 2018, in that it's continuing to attempt to enforce default judgments that no longer exist, because this court has set those default judgments aside. Now, I mentioned this very briefly just before the hearing, it's fair to say, to Mr. Abbott and Mr. Jury, and indicated to them that we intend to seek from the claimant either an undertaking that they will cease and withdraw any enforcement action, or alternatively, if they're not in a position to do that this morning, which may be possible given the need to obtain instructions from London, that we would seek a no less order, essentially that they are required by order of this court, Your Excellency, to withdraw steps to seek to enforce the now non-existent default judgments, following failing which we would invite the court to order unless.
I think I can solve this issue without any. We need to issue a letter from the IFC court saying that this order dated so and so. It's a stay until the outcome from the default judgment or jurisdiction application. This is easy, and many times we did that, and other.
And indeed, Your Excellency, we've actually written ourselves to our local council has written also to the registry in this regard in relation to this.
And the registry reply on you or not yet?
Your Honour, good morning. Not yet. We have requested a few days ago a letter from the registry of our court.
So I'll be sure that the letter will issue before end of this week.
Thank you, Your Honour.
But what I request that follow up with the registry. I'll give them the direction now and follow up with them, please.
Thank you, Your Honour.
Haja?
Give me a second.
Yeah, Mr. James, give me a second. Just to write a note that. we have to issue a letter to Sharjah Court to stay proceeding regarding enforcement. I will take care of this. Yes, Mr. James.
No, Your Lordship, in the light of what you've said, I have nothing further to add.
I'm very grateful. In that case, we can continue with the application. So, as I say, Your Excellency, this is defendant's application to contest jurisdiction. Just to give you the very brief chronology, it's not in dispute. Our application notice was submitted on the 11th of February 2018. This followed the court having set aside 2 default judgments I just mentioned. The initial claim form, Your Excellency, commencing these proceedings was issued on the 4th of May 2016. The claimant issued an application notice for permission to serve the claim form by alternative method at certain email addresses, some of which were said to be email addresses of the defendants and some at my firm's White Hat and Box. I need not take Your Excellency to that application notice. That application was heard without notice, and the court granted the order in the terms sought and as drafted by the claimant. Your Excellency, that is the order for alternative service. For the court's records, it's in the hearing bundle, and again, we need not look at it, but the hearing bundle, tab 4, pages 31 to 32. But that's the order for alternative service. Your Excellency, my firm wrote to the court indicating it was not instructed, following which the claimant filed 2 requests for default judgment, and the court granted them. Once the defendants became aware of these default judgments, my clients applied to set aside those default judgments, which the court did so set aside on the 21st of January 2018, following a hearing in this court. The defendants, and to complete the chronology, the defendants acknowledged service and applied to challenge jurisdiction on the 11th of February 2018, as I said, and this is the purpose of this morning's hearing. We are challenging jurisdiction on 2 broad bases. One, that we are challenging the order for alternative service, which we say goes to jurisdiction, and secondly, we are challenging the statutory jurisdiction as set out in Dubai Law 12 of 2004 as amended. I intend to present my submissions this morning in that order, and as Your Excellency has already heard, Mr. Farhad will also be making submissions. The structure of my submissions, dealing first with the challenge to the order for alternative service, that is based on RDC Rule 23.94. I will very briefly, Your Excellency, set out the law to set aside an order. Secondly, I will make submissions to show why we say the order for alternative service is effective. Thirdly, I will then explain why this court should not grant Mr. Abbott's clients any relief from sanctions applying the Denton test, as it's called. And then finally, we would say that there was no good reason with respect to this court ever to have granted the order for alternative service. Having addressed that issue, Your Excellency, I intend then to turn to the challenge to the substantive jurisdiction of this court based on RDC Part 12. We say in particular, Your Excellency, that there's no gateway to jurisdiction under Dubai Law 12 2004. Indeed, it appears the claimant is no longer relying on any alleged opt-in, given that certain arguments will address that. What the claimant does now argue is that the agreements were not concluded or performed within the DISC. We say that's not the case. We also say, Your Excellency, there's been no submission to the jurisdiction. Finally, we will turn to what appears to be the claimant's core case on jurisdiction, which is that Standard Chartered Bank is an establishment for the purposes of the 2004 law. We say that contrary authority is distinguishable, and finally Mr. Farhad will conclude and explain why the effect of the claimant's interpretation, if the court accepted it, would give rise to an exorbitant jurisdiction. So I intend to address these issues as briefly as I can, Your Excellency, given the time limit set for this hearing. So the law one set aside for the order of alternative service. The service of the claim form, Your Excellency, is dependent upon the order for alternative service. The purported service of the claim form was said by the claimant himself in the certificate of service to have been served in accordance with the order for alternative service, i.e. at the relevant email addresses. It's well known that the law is, both in English litigation and also in litigation we say before the DISC courts, that if an extension of time permitting service or an order for alternative service is set aside, then the actual service made pursuant to that order is no longer valid. And Your Excellency, that can very briefly be seen from the commentary to the English White Book, which can be found in the defendant's legal authorities, tab 5.
Tab 5, no?
Tab 5, Your Excellency, yes. And Your Excellency will see there, this is a commentary, page 40, on Civil Procedure Law 23.10, which is the equivalent to 23.94. If one turns the page 41, Your Excellency, and about a quarter to a third, about a third, 40% of the way down, there's a paragraph which starts, a claimant who. So it's the third substantive paragraph, if I may just read that out for the court. A claimant who, on an application made without notice, gets an extension of time for service of their claim form, does so at their peril, and should know that it may be set aside by the defendant's application under Rule 23.10. There's a citation there to Hodden, Simon Holmes. Now, Your Excellency, we say the same proposition stands under the RDC, and it also stands in respect of an order for alternative service. So we say if this is defective, then this court does not have jurisdiction to hear this claim. If we may perhaps, Your Excellency, turn back to tab 4 in the defendant's legal authorities, and in particular to page 38. This is the excerpt from the RDC themselves. And Your Excellency will see on page 38, 23.93, which is the relevant rule of applications. It says, this rule applies where the court has disposed of an application which it is permitted to be made without service of a copy of the application notice, and then for 1, where the court makes an order whether granting or dismissing the application, a copy of the application notice, and in here, for instance, the court must, unless the court orders otherwise, be served with the order on any party or other person against whom the order was made and against whom the order was sought. And then 2 says the order must contain a statement of the right to make an application to set aside or vary the order under Law 23.94. And finally, Your Excellency, 23.94 of course provides a person who was not served with a copy of the application notice before an order was made under Law 23.91, which is the general provision for orders, may apply to have the order set aside and vary. So the simple point is, and I'll then move on, is the application notice was not served before the order for alternative service was granted. Therefore, the defendants were entitled to apply to set it aside as of right. So, turning then to our grounds of challenge to the order for alternative service, we say it was defective in a number of ways, a number of important ways. First of those ways was that there was no statement of the right to challenge. Your Excellency has just seen 23.932 says that the order for says that an application, here the order for alternative service, must include a statement of the right to apply to set it aside. It's not in dispute, there was no such statement in the order here. The claimant, we say, appears to accept that this failure to do so was in breach of the RDC. And this is why, I need not take you, paragraph 1 of its skeleton argument, paragraph 41 of its skeleton argument, it has now sought an order seeking to remedy its defect in this respect, which I'll come to momentarily. The point, however, Your Excellency, is that this is no mere procedural error. So, turning then to the second manner in which the order for alternative service was defective, 23.93 also requires service of the application notice and evidence filed in support. And Your Excellency has just seen in 23.93 subparagraph 1. Rather bizarrely, we suggest, Mr. Abbott says that the court made an order otherwise. with respect, this is based on a misreading of RDC 23.93 and the order. The court did not order otherwise. It made an order for service of the claim form and the order for alternative service. It did not say the claimant applicant is not required to comply with 23.93, nor did it say it's not required to serve the application notice and evidence or anything akin to that. The order made no reference at all to the application notice or evidence in support. It only dealt with service of the order itself. So the failure to serve the application notice and evidence after the order was made was, we say, a clear breach of the provisions of the RDC. Now, the claimant cannot rely, we say, on its own failure to include the relevant paragraphs in the draft order, because a proper order for service is one which needs to be served. So the point essentially is that the claimant cannot rely on its own default in this regard. Third point, Your Excellency, correcting procedural defects. The claimant has made a submission, paragraphs 33 to 34 of the skeleton, I need not take you, that the failure to serve the application notice either before or after the hearing was a mere procedural defect. Now, with respect to Mr. Abbott and his clients, we say this seriously misunderstands the nature of an application under 23.94, or indeed the English Civil Procedure Rules equivalent. This is a fundamental right that permits a defendant to apply to set aside a court order that's been made in the absence of the defendant. Remedying service of a claim form is, we say, very different to an ordinary application that one may have in the course of a hearing. Now, the claimant relies on a case called Integral Petroleum, which I'll take Your Excellency to very briefly in a second, and it says that in that case, Mr. Justice Popperwell and the Commercial Court in London allowed the equivalent relief to remedy service of a claim. But if one sees what the case actually says, and Your Excellency, you can see this in the claimant's legal authorities, the different bundle, the claimant's legal authorities, tab 6. Tab 6, this is the decision relied on by the claimant, and the relevant paragraph, paragraph 37 on page 124. And paragraph 37 starts, and I won't read the whole thing, just the first sentence or two. This case is not concerned with service of originating process, but service of petitioner's claim. To my mind, this is a significant distinction. A narrower approach to CPR 3.10 is justified when it is sought to be applied to the service of originating process, because service is what establishes in personam jurisdiction over the defendant. Now, Your Excellency, this is exactly the point here. The order to return to service and the claim form relates to the service of the originating process, the claim form, not the particulars of claim or some other such document. Again, with respect, we say this case actually undermines Mr. Abbott's argument rather than supporting it. Likewise, Your Excellency, at paragraph 35C of Mr. Abbott's skeleton, again, no need to take, he says that he suffered no prejudice. Well, again, with respect, that misunderstands the structure and purpose of the rule. And we are inherently prejudiced, we say, by not being able to turn up and contest the order. And that point can be very neatly made, Your Excellency, by looking briefly back in the defendant's legal authorities, the same authority I took you to, at tab 5. The defendant's legal authorities, tab 5, page 40. And this again is a commentary in the White Book on the equivalent rule. Third paragraph, where the court makes an order on an application made without notice, the applicant must serve on the respondent the material referred to in 23.92. That's in similar terms to 23.94, the RDC. And moving on, Your Excellency, to the next paragraph, and this is my point, rules 23.9 and 23.10 provide the respondent with protection where the court's order whether for substantive relief or case management was made without him or her having had an opportunity to present a case to the judge, it is clear, both at common law and under Article 6 of the Convention, that there must be such a right. Now we say, a fortiori, that must apply in relation to orders permitting service which founds the fundamental jurisdiction of this court. Now, Your Excellency, we say that perhaps Mr. Abbott now sees the error in the approach suggested previously because he has now sought to apply for relief from sanctions. Now, the relief from sanctions regime is one which requires an application to be made. The claimant has not made such an application. It's not issued an application notice, paid the appropriate fee. Again, with respect, we say this is not a minor error. And any application would need to have been supported by evidence of the reasons for the error made by the claimant here, by the RDC. There is no such evidence before you. And again, this is despite, and again, I need not take you, it can't be in dispute, RDC 4.50 sets out the express requirement for an application to be supported by evidence. As a result, Mr. Abbott and Mr. Drury are in the unenviable position of needing to essentially give evidence as to why they say relief from sanctions should be granted. And of course, we as defendants have had no chance to reply by evidence in response. If I could just ask Your Excellency to turn very briefly to the claimant's skeleton argument, which can be found in the main hearing bundle at tab 20.
And which point?
Tab 20, Your Excellency.
No,
the main...
I have that.
I apologise. It's paragraph 39, Your Excellency. And one can see here, at 39, it says, SCB has satisfied each of the stages of the test for relief from sanctions as set out in Denton, and as a result should be granted where A, the alleged error was a mere procedural error and neither serious nor significant. Moreover, the defendants have not highlighted any way in which they've been prejudiced by this alleged error. Well, again, with respect, the point is the first we knew about this so-called application was in Mr. Abbott's own skeleton argument. We say that's inappropriate and inconsistent with the clear provisions of the RDC. Likewise, at 39B of the skeleton argument, Your Excellency, it says the alleged error was entirely unintended by SCB. Well, there's no evidence on that. That's, with respect to Mr. Abbott's conjecture. So we say the court should not consider the application for relief from sanctions because no such application has been made. But even if the court were to do so, we would say there's simply no grounds to grant such an application. And I'm just going to hand up to the court something which I gave to Mr. Abbott this morning, which is the commentary. It's the simplest way into the Denton issue, which has become complex. This is the White Book commentary on the relief from sanctions regime, which we say is easier to grapple with and have to go through all the cases. And if Your Excellency just turns the page to the second page, at paragraph 3.93 of the White Book on page 111, the editors of the White Book explain there's a threefold test. The first stage is to identify and assess the seriousness and significance of the failure to comply. If the breach is neither serious nor significant, the court's unlikely to need to spend much time on the second and third stage. The second stage is to consider why the default occurred, and the third stage is to evaluate all the circumstances of the case so as to enable the court to deal justly with the application. So taking each three in turn, very briefly, was it serious or significant? Now we say the effect on the litigation as a whole should be considered. The requirement is one of natural justice. If the respondent is not present at the hearing, it obviously needs full knowledge as to what happened and what was said before the judge, and which applications were made, and which evidence was submitted in support, in order to allow that defendant to consider whether the court's decision was correct or not correct, or whether it would have a chance to appeal. to challenge it. So we would say it's clearly a significant breach. The effect on other litigation of failures to abide by court rules on service is substantial. As I've explained, it goes to the core issue in a common law system, as the DIFC is, whereby service is the foundational basis of the court's authority. There are two breaches: the breach of the requirement to give notice of the right to challenge, and the failure to serve the evidence and application notice. Again, we say these are fundamental questions, hence the reference to must in 23.932. This, in turn, has led to unnecessary correspondence, led to unnecessarily protracted proceedings. So again, we say the effect of this breach is clearly a serious one, because it interferes with protections granted to parties not present. Second issue, Your Excellency, why the default occurred. The question is whether the claimant has shown a good reason for the breach. Now, good reason, we say, is a high test under Denton, and again, that can be seen from the commentary I just handed up to Your Excellency over the page, on page 112. And it's at paragraph 3.95, and it says, the second stage is particularly important where the breach is serious or significant. The court declined to give any examples of this in Denton. The court declined to give any examples of good and bad reasons for failure to comply with rules, practice, directions, or court order. The court, however, did not disapprove of the examples previously given in Mitchell, which effectively was another court of appeal practice note on this issue, but stated that they were no more than examples. In Mitchell, the examples given were as follows: the fact that the defaulting party or his solicitor suffered from a debilitating illness or was involved in an accident. Later developments of the course of a litigation process, if they show that the period for compliance originally imposed was unreasonable, although the period seemed to be reasonable at the time and could not realistically have been subject to an appeal. And then it concludes, good reasons are likely to arise from circumstances outside the control of the party in default. Now, Your Excellency, we say here there was no good reason. The breach was intentional, not intended in the sense that Mr. Abbott's clients intended to breach the rules, but that is in the decision to serve the application notice without the relevant requirements was not something that happened by accident, but rather a misunderstanding, it seems, of the law as to what needs to be provided. A misunderstanding, we say, which could not reasonably be reached given the clear language of 23.93. So we say this misunderstanding is very much within the claimant's own control. It's not something outside it. Turning to all the circumstances of the case, this is a broad brush test which needs to consider a range of factors. But we say they point here to the claimant not being granted relief from sanction. And again, if one looks finally, the last bit of this commentary I handed Your Excellency and turn the page again, to page 113, we deal with promptness. There's a reference there to the case of British Gas Trading at the top. In British Gas Trading, you know, cash and carry. The Court of Appeal regarded the defendant's lack of promptness in applying for relief from sanction as the critical factor for consideration at the third stage. Had the application been made promptly, it would have been granted. However, when the delay in applying for relief was added to all the other factors, it could be seen that the defendant's default had substantially disrupted the progress of the action. The application for relief was refused. Now, here, Your Excellency, the claimants have known for some time about this error. In correspondence from my firm on the 14th of September 2017, need not take you, but for your reference, it's in Appendix B, tab B4, page B16. This was highlighted. Similarly, Mr. Abbott and his clients knew that this application would rely on it for making of an application to set aside default judgment. Similarly, the claimants knew of this application at the very latest, since the 11th of February, when the application notice was served. Yet there was no application over all of these 8 months for any relief from sanction, despite it being pointed out many months earlier, apart from a Mr. Abbott's certain argument at the end of last week. So we say the sanction of setting aside the order for alternative service is an appropriate and proportionate response in terms of dealing with the overriding objective to deal with the defects which I've identified. The faults went to the ability of the defendant to challenge the order, the failures are significant, and the obligations were clear. We therefore say there was no basis to order relief from sanctions. Turning then to the final aspect of the application to set aside the order for alternative service, good reason. Now, the claimant was required to show that there was a good reason to obtain the order for alternative service itself. For your reference, that's set out in RDC 9.31. Now, we say there was no good reason for the order to have been granted for a number of reasons. In particular, the claimant failed to make substantial efforts to serve the claim form under RDC 9.54. It was permitted to serve by any method which was lawful in Sharjah, as RDC 9.54 provides, but it failed to use the range of methods which were properly available. Now, briefly, Your Excellency, I can show you this in our skeleton argument, so the defendant's skeleton argument, at paragraph 34 onwards. I may very briefly take Your Excellency there. Paragraph 34. And we can see at 34 how we explain service in Sharjah, and of course Your Excellency is far more familiar than I am. Service in Sharjah is governed by the UAE Civil Procedures Code. Under Article 5 of the Code, the core methods are method agreed, process server, or specified methods prescribed by law. Now, as we say in paragraph 35, despite the wide range of methods of service permitted in the Emirate of Sharjah, only limited efforts had in fact been made. And this can be seen, Your Excellency, over the page at 36. No effort was made to serve the general managers of the defendant personally, despite this being permissible. Indeed, little use was made of the broad provisions for permissible methods of services on companies in Article 9.2, and there's a reference there to delivering at their administration centre to their legal representatives. And just to conclude, at paragraph 37 and 8, there was little or no evidence of inquiries as to the proper address of service having been made once formal service had failed, and similarly, the claimant gave no explanation for how a bank failed to keep up to date contact details of one of its clients said to owe many millions of dollars. And finally, at 38, Your Excellency, there were other steps available quite properly under the Civil Procedures Law. These were not taken. No notice of the claim was published in the press, which is, of course, an ordinary method to effect service when the other methods have failed. Similarly, the claimant did not apply to the courts of Sharjah into an inquiry into the address of the claimant. And we say these efforts could have been made rather than seeking to apply for the order for alternative service. So, with respect, we say there was therefore a material non-disclosure made by the claimant in making this application for the order for alternative service. By one, failing to explain the range of permissible methods of service available under RDC 9.54. Secondly, it failed to explain the law of service in Sharjah. And thirdly, it failed to explain the other methods that were open to the claimant. In sum, without examining the law of Sharjah to see how far the claimant had attempted service under RDC 9.54, there was no evidence before the court by which it could determine whether there was or was not a good reason. Therefore, we say this order must be set aside. That, Your Excellency, is the first ground. The second ground is that there was also no good reason to use the proposed method set out in their application, i.e. the email addresses specified. First, the court was not in a position to determine that this method of service was not unlawful in the Emirate of Sharjah. The court is required not to make an order for service by an unlawful method. That's set out in RDC 9.55. So again, to conclude, we say that the material non-disclosure by the claimant, in one, failing to draw attention to this requirement, and two, not to provide evidence of the law of Sharjah in this regard. And then, finally, There was also material non-disclosure, we say, in respect of the fact that there was insufficient evidence that service at those email addresses, so that writing to the defendants at those email addresses would bring it to defendants' attention. And Your Excellency, briefly, you can see that from our skeleton argument at paragraph 48 onwards. And I don't think you can read it, but I'll briefly take Your Excellency. 48, and particularly 49, we say the claimant had inquired of Squire Patton Boggs before making the alternative service, whether it was instructed on this matter by IGPL, and we confirmed that it was not. Paragraph 50. Squire Patton Boggs was not at that time instructed to act foul law in any capacity, and there was no evidence before the court it was. The claimant's suggestion that the alleged common ownership of the defendants gives rise to some presumption that service on the laws of one company should be service on another company is clearly inadequate. These companies, of course, have separate legal identities. Thirdly, at paragraph 52, the claimant provided little evidence that the email addresses would actually bring the claim to the attention of the defendants. Indeed, at 53, we say it was implicit in the claimant's evidence that no read receipt had been received. Now, it's a matter of ordinary commerce, judicial notice. Just because no bounce back or undelivered receipt is sent does not mean that the emails were delivered. And finally, we say the claimant failed to include email addresses to the legal department or indeed the other more general addresses of the defendants. Instead, and this is really the matter which gives rise to some concern, the claimant failed, this is paragraph 56, the claimant failed to inform the court that Mr. Subert had, as Mr. Eldoz confirms, left foul oil in April 2015, and an email to that address could not come to the attention of foul oil. The strange thing is here, though, Your Excellency, is the bank was itself in communication with Mr. Eldoz at the time. All the claimant and Mr. Abbott says in his skeleton argument about this is that these emails did not come from the team at his clients dealing with servicing the loan, but they came from another department. Well, Your Excellency, the fact that one part of the bank does not know what the other part is doing is not really a good reason. So we say all of this constitutes immaterial non-disclosure. Now, the claimant relies on the case of Pearl Petroleum, well-known authority here, need not take Your Excellency, to claim that there's no requirement for an applicant on a without notice application to set out in full every argument that may be made by a respondent. Well, we respectfully agree. The point here, though, is that the claimant failed to put forward any potential argument that defendants may have made. It failed to draw the court's attention to the fact that it had not gone through the normal additional methods set out by civil procedures law in Shropshire. It relied on an erroneous legal basis to assert this service on my firm, supposedly on behalf of IGPL, who, was not instructed to accept service, but somehow bring this to attention of foul oil. Further, they failed with respect to check their own systems that would show that the persons they email were no longer at the defendants, despite the fact another part of the bank was already emailing my clients. So this is not a failure to put forward every conceivable argument. This is a failure to draw material and relevant facts to court's attention that would have meant there was no good reason to order service by an alternative method. So for all these reasons, Your Excellency, we say the alternative service should be set aside. And if that's the case, given that the claim form was served pursuant to the order for alternative service, no service has been effected and the claim should therefore be dismissed. Your Excellency, that completes my submissions in relation to the order for alternative service. Turning therefore to the challenge to the substantive jurisdiction of this court based on RDC 12. This, as Your Excellency knows, is based on Article 5 of Dubai Law 12, 2004. Your Excellency, of course, will have this in mind, but it can be found in the defendant's legal authorities at tab 7. Now, as Your Excellency knows, this law has been through a number of amendments. What we are looking here is for material, in all material respects, the law is relevant for these proceedings. So it's at page 50 of the bundle, tab 7. And Your Excellency will see at Article 5A, the Court of First Instance shall have exclusive jurisdiction and rule over 1. Civil or commercial cases and claims involving the centre or any of the centre's bodies, any of the centre's establishments, or any of the centre's licensed establishment. That's the establishment ground. 2, so this is B, 5A, 1B. Civil or commercial cases and claims arising from or related to a contract or promise to contract, whether made, concluded or executed in whole or in part in the centre, or will be actually executed or supported to be executed in the centre according to explicit or implicit terms stipulated in the contract. And then you move on. In particular, if we look at Article 5A2, there are other grounds which are not relevant here, and it explains the Court of First Instance may consider and rule in civil and commercial cases and claims, if submitted thereto by the agreement of the parties in writing, whether before or after the dispute, provided that this agreement must be according to clear and explicit special provision. So there are a number of gateways, in essence, in Article 5A. The third gateway that's addressed in the skeleton is that the first is that of opt-in, which we've set out in our skeleton based on 5A2. Now, however, Mr. Abbott's skeleton does not deal with that, so I don't intend to focus on the opt-in point. Instead, I intend to focus on the ground set out at 5A1B, which is whether the agreement has been agreed or is to be performed in the DIFC. Now, we say the following. The agreements were not concluded or performed in the DIFC. The claimant now alleges this is the source of jurisdiction. It did not mention this, Your Excellency, in its claim form as being the basis of jurisdiction. We say this is unsurprising, as in fact it's not supported by evidence. So let's deal first with whether the agreements were or were not concluded in the DIFC. And if I can take Your Excellency to Mr. Eldoz's second witness statement, and this can be found in, I just have it in front of me here, this can be found, Your Excellency, in Appendix A to the hearing bundle.
Okay, but in which number 1 or 2? Which file?
It's Appendix A, File 2 of 2 of the and tab 10 of the hearing. Tab A10. So Appendix A, File 2 of 2, tab 10. I apologise, I'm dealing with a number of different bundles.
Are you sure it's file number 2? No, because file number 2, nothing. Only the contracts and agreements.
My apologies, Your Excellency, it's actually file number 3. Sorry, I'm working off a slightly different bundle. My apologies.
Tab 10?
Tab 10, file number 3. My apologies for that.
Witness statement.
Of Mr. Eldoz, exactly. Second witness of Mr. Eldoz. And Your Excellency will see there over the page, at page A307, what he explains. In each case, the facility agreements were negotiated with SCB's branch in Dubai. At no time was any business done with the DIFC branch of SCB, nor was any business done with SCB with the DIFC. Standard Chartered's relationship manager for Foul Oil was Mr. Ibrahim Jarid of Standard Chartered Bank Wholesale Banking, Al Mukul Road, Dubai, PO Box 999, Dubai, United Arab Emirates. Now, the facility agreements, that's the evidence on this. Now, the facility agreements are separate agreements, as Your Excellency knows, for differing amounts. Now, the only evidence put forward on behalf of the claimant is that of Mr. Swami, which can be found in the same bundle Your Excellency is in at tab 15. So the same bundle, tab 15, which is the second witness statement of Mr. Swami, and in particular at paragraph 12. Now, and it says here, in particular, I understand from Mr. Sif that the facility letter, which as confirmed in the affidavit, as confirmed in the affidavit, is the latest revision of the FAL facilities, and therefore contains the terms and conditions applicable to the FAL facilities, unless otherwise supplemented by the earlier facility letters. And it was negotiated by the GSAM division of the respondent. Therefore, given that GSAM is based within the respondent's office in the DIFC, the facility letter would have been negotiated in the DIFC. Now, the point here, Your Excellency, is that this is simply referring to the facility letter. And if one goes back a couple of paragraphs, to paragraph 5A, which explains this term, facility letter, so turn back the page to paragraph 5 of the witness statement, he explains the facility letter, dated 8th of April 2012, is at Exhibit AV6, pages 68-75 of the first affidavit of Mr. Silf following these proceedings. So that's the point, essentially, Your Excellency, is that this is only dealing, and it is clear by the reference to the earlier facility agreement, it's only dealing with the facility letter of 8th of April 2012. It's not dealing, Your Excellency, with the earlier facility letters. And indeed, this can be seen. If I take, Your Excellency, again to Appendix A, which is in Bundle 2. I think much more moving around, Your Excellency. I apologise. Appendix A, Bundle 2, Tab 4. And if one looks at tab 4, Your Excellency, I'm afraid we need to go to page 265, A265. And this is the 2012 letter itself. So, obviously, the other letters, we say there was no evidence at all that they were done in the IFC. Instead, they were clearly done in Dubai, as we said. If one looks at this letter, page 265, at the bottom, there's the address, bottom left-hand corner, Standard Chartered Bank, Wholesale Banking Legal Credit Department Unit, PO Box 999, Dubai, United Arab Emirates. And that this is Dubai rather than the DIFC is clear by turning to the end of the letter where it's signed at page A270, a couple of pages on. At the bottom of the letter, it says, for and on behalf of Standard Chartered Bank, Dubai branch. So the simple point there is even the 2012 letter clearly was not an agreement entered into within the DIFC. The same can be seen if we go to the IGPL guarantee.
You want to say, just to make it short, you want to say the branch would sign an agreement, this is not the IFC branch, this is a...
Correct, Your Excellency.
As a simple saying. There's no establishment until this agreement registered with the IFC.
Your Excellency, correct, yes. So, and we will certainly be coming in more. Mr. Farhad will deal briefly with the establishment point. But my point is these agreements were not concluded within the DIFC because it was an agreement between FAL Oil and also the Dubai branch of Standard Chartered Bank, not the DIFC branch. And the same point can also be seen, and this is the last one I'll take you to, if we look at the exhibit to Mr. Taunton's witness statement, which is in bundle, so appendix A, in appendix A, bundle 2, which may be the same bundle Your Excellency is in.
Okay, sir.
It's tab A07, and it's a long way into that tab, I regret to say, at page 461. So, Appendix A, Bundle 2, Tab 7, almost at the back, page 461, which is the IGPL guarantee.
Guarantee.
Yes. So this, Your Excellency, is the IGPL guarantee, and if we turn a couple of pages to page 465, which is the signature page, Your Excellency will see Bank Branch Dubai, Customer FAL Oil Co Limited, IGPL, and Your Excellency will see there the point. Now, it's only signed only by IGPL, not by Falloil, but it's clearly agreed outside of the DIFC, and that can most clearly be seen if Your Excellency turns back to 462, the very first page, where it defines bank definitions. The very first definition: bank means Standard Chartered Bank acting through its branch specified in the schedule and its successors and assigns. And the branch, as Your Excellency has just seen from the signature strip, is Dubai. Clearly agreed outside the DIFC. Now, that, we say, deals with the agreements were not entered into in the DIFC. I think that's, we say, very strong evidence that's the case. Let's then turn briefly to performance. The first defendant, which bears the payment obligation, is based in Sharjah. The guarantor clearly has no performance to do in the DIFC. As we've just seen under the IGPL guarantee, the agreement was expressly entered into with the Dubai branch. Payments to be made to the bank branch, as I've just shown. In these circumstances, it's clear that performance is to be made to by IGPL and then in Dubai and then to the bank branch in Dubai. The claimant is not entitled, Your Excellency, to seek to change the place of performance by moving administration of these accounts. These are important legal issues which clearly set out and define the legal relationship between the parties, which set out whether this court does or does not have jurisdiction on this ground. There was certainly no characteristic performance of these agreements as obviously the party performing it, not the bank simply there to receive money. So we say there's no jurisdiction over claims under these agreements relied on, either for the first defendant, and Your Excellency see even there as regards to 2012 that there may have been some argument, even there that's very weak given what I just showed you about the Dubai branch. As regards the second defendant, there's no sustainable argument at all. So that, we say, disposes entirely of the first gateway. If we turn then to next gateway, which is, has there been a submission to the jurisdiction? Now, Mr. Abbott submits that the defendant submitted to the jurisdiction of the DIFC courts by applying to set aside the default judgments. Now, this is set out in his skeleton argument. I need not take you to paragraph 26. He claims that the defendants did not indicate that they intended to challenge jurisdiction in the set-aside application. Now, with respect, this is wrong. And this can be seen from the main hearing bundle. I need not take you, I'll give you the reference. The main hearing bundle, tab 10, page 50, paragraph 4 of our application to set aside default judgment. We expressly, in that application, set out that we disputed the jurisdiction of the DIFC courts. In any event, we say this is a surprising submission. A challenge to default judgment is not a submission to the jurisdiction. The claimant relies on the case of Newland, which I'll very briefly take, Your Excellency. It's the claimant's legal authorities, bundle 1, tab 4. And in particular, it's paragraph 18. Now, the claimant, as I say, relies on Newland to seek to show that applying to set aside a default judgment is apparently a submission to jurisdiction. But let's see what Newland actually said. 18. While I can appreciate from the claimant's perspective the lack of challenge to the default judgment may seem anomalous, I consider that the claimant's argument does not really bite. And it then sets out some provisions, and at the bottom it says, it certainly seems possible that an argument that challenging the default judgment in partnership with a jurisdictional challenge might be said to amount to a submission to the jurisdiction in circumstances where the authorities tend to suggest that any step in relation to the merits of the claim can amount to a submission, as then some cases cited. Accordingly, it seems to me that the fifth defendant was entitled to form the view that it was unsafe to apply to set aside the default judgment now, and the course of action taken cannot fairly be described as wrong. On the contrary, challenging jurisdiction was logically the first step, whether or not it might have been combined with a very cautiously worded challenge to default judgment. Now, the point here, Your Excellency, is the court was explaining why it might have been possible or justifiable for a party challenging jurisdiction not to have challenged the default judgment. The court was not saying that a challenge to a default judgment amounts to a submission to the jurisdiction. Rather, the court simply said that an overly cautious defendant might be concerned about this, and that's why such a step would not be unreasonable. Here, however, in this case, the challenge was clearly appropriate and cannot amount to a step taken on the merits for this very simple reason. It would otherwise be impossible to contest jurisdiction. RDC 12.2, and I need not take it, Excellency, provides that a defendant must first file an acknowledgement of service when served with the claim form. However, once a default judgment has been entered, it's impossible to file an acknowledgement of service. The claimant's argument would therefore mean that the claimant could issue a claim form, apply for default judgment without ever actually completing service, and if the court in error entered that default judgment, that would have erased any possible jurisdictional challenges, because the only way, Your Excellency, in which a defendant wishing to challenge jurisdiction when faced with a default judgment could do so is to apply to set aside a default judgment. It cannot simply file the acknowledgement of service and tick the box and it disputes jurisdiction. It has to apply to set aside a default judgment. Accordingly, we say the reference to the point in Newlands does not assist Mr. Abbott, and it's clear there has been no submission with respect to this court's jurisdiction. That therefore disposes, we say, entirely with the second gateway. Turning to the third and final gateway, not an establishment. This appears to be the core of the claimant's case on jurisdiction, that it is an establishment under Article 5.1a of Dubai Law 12 of 2004. This is the one that appeared in its claim form. This is the one it has relied on consistently. If one briefly looks, therefore, at the provisions, and I know Your Excellency has them in mind, of Dubai Law 12 of 2004, which Your Excellency will see at DLA 7, Defendant Legal Authority 7. That's the provision. I need not read it again, but it clearly sets out the provisions regarding establishment. That, Your Excellency, is the relevant provision. However, an examination of this law has shown that there have been considerable changes to the legal position in recent years. The claimant says that it is an establishment because it has a branch. It's because it has a branch in the DIFC that it is therefore a licensed establishment. The claimant says that this status extends not just to that branch, the DIFC, but instead extends to the entire legal entity. We say that this is not correct. Further, we would submit this incorrect interpretation would lead to an exorbitant jurisdiction. I will explain why in law this interpretation is, we submit, wrong, and previous authority that might be said to support it ought, with respect, to be distinguished. Mr. Farhad will then conclude, setting out why the jurisdiction the claimant seeks of this court would indeed be exorbitant. So any contrary authority, we say, is distinguishable. There are two previous authorities that may appear to suggest, on first glance, that the claimant is correct in its interpretation. These authorities are claimed by the claimant to show, one, that the term establishment should be interpreted as extending to the entire legal entity, whereby any part of that entity, such as an unincorporated branch, would qualify as an establishment. Secondly, these authorities are supposed to show that the jurisdiction would not be exorbitant because of the existence of the opt-out in the unamended version, i.e. the original version, of Dubai Law 12 of 2004, and the fact that there existed the doctrine of form non-convenience between UAE courts, or rather the IFC court thought that there existed the doctrine of form non-convenience before the UAE courts. Each of these decisions are, with respect, distinguishable. In both cases, they were based on assumptions, Your Excellency, as to the law that no longer hold true. The first case is the case of Corinth, which Your Excellency knows. This case is based on the earlier version of Law 12 of 2004, which then applied. It's correct to say the decision itself was rendered after amendments to the law were made. However, the case related to the earlier version of Law 12 of 2004, and the court invited no arguments from counsel on that point. This can be seen, Your Excellency, if I may take you very briefly, to Defendant's Legal Authorities, tab 12, which is the decision in comment itself. And in particular, the paragraph 86 of the judgment, which is page 118 of the bundle, which is the concurring judgment of John Chadwick. And Your Excellency will see there, I'll just wait for you to find their apologies. So, Defendant's Legal Authorities, tab 12. And in particular, page 118, Your Excellency, right at the bottom of the judgment. So, one can see here, paragraph 86, this is the concurring judgment of Sir John Chadwick. As the Chief Justice has pointed out, the appeal was argued necessarily in the circumstances that Law number 16 of 2011 had not been issued when the appeal was heard. That is, of course, the law amending Law 12 of 2004, on the basis of provisions in the original law as issued. In those circumstances, not be able for the court to invite further argument on the basis of law as it now stands, following the issue of Law number 16 of 2011. And it then continues, but particularly when it's at the bottom, where it says, in any event, it is clear from the judgments in this case that the outcome of its appeal would have been the same on the basis of a law as it stood before the issue of Law 16 of 2011. So, Your Excellency, that is an obiter, non-binding comment made without argument, but the benefit of argument by Sir John Chadwick. It's clear, however, we say, from the judgment that the very foundation of the reasoning in comment no longer, with respect, amounts to good law. And we say this for this reason. First, the Court of Appeal, in that decision, made it clear that they based their finding that jurisdiction was not exorbitant because the parties were able to agree to another jurisdiction, i.e. the opt-out, based on the provisions of the unamended Law 12 of 2004. And if I could very briefly, if we keep open the decision, if I may, well, we actually can't use the same bundle, but if we flick very briefly, Your Excellency, to Defendant's Legal Authority, tab 6, we will see there the original law, DLA tab, Defendant's Legal Authorities, tab 6, and in particular page 45. And we see there Article 5, and then particularly Article 5, Article 5A2. Parties may agree to submit to the jurisdiction of any other court in respect of the matters listed under paragraphs A, B, and D of this article. So that, Your Excellency, was the original provision. If we turn to tab 7, and we see the provision which in material respects as it is now, page 50, tab 7, 1, 2, 3, 4, and we'll see at 5A2, it no longer talks about opting out. It says instead, as I read to Your Excellency earlier, the Court of First Instance may consider and rule in civil and commercial cases and claims if submitted thereto by the agreement of the parties in writing. So essentially,
actually,
an opt-in.
The Arabic version much more clearer than the English. It's the amendment of the Article 2 or Article 5.2. It's coming with in the new version is Article 5.3. But unfortunately, the English version is here.
I'm grateful, Your Excellency, for that indication. So 5.3 says the court may consider and rule if the parties agree in writing on jurisdiction of another court and was rejected by that court due to the want of jurisdiction. So this, as Your Excellency very helpfully points out, is Article 5A3. But of course, even Article 5A3 is in very different terms. We submit, at least in the English translation, and I know Your Excellency, of course, has in mind the original and authentic Arabic. that if one looks at Article 5A2 of the one behind tab 6, that simply says the parties may agree to the jurisdiction of another court, whereas the new law says the court of first instance may consider and rule in these cases, provided that this agreement must be according to a clear and special provision. So, my apologies, may rule in these cases if the parties agree in writing for jurisdiction of the court and was rejected by that court due to want of jurisdiction. So we say that's a tougher hurdle. The parties can't simply agree to opt out. They have to agree to opt out and the other court has to have declined jurisdiction. At least that's how I read it, Your Excellency, in the English, though of course I appreciate it's the authentic Arabic, but
if that court reject the jurisdiction, then by default this court has a jurisdiction to hear the matter.
Well,
originally has the jurisdiction.
I think the point, Your Excellency, would be that if parties, I think the point would be that it allows the parties to
Opt out.
Well, the original law allowed the parties to opt out, whereas this law is permitting them, we would say, to opt in, but only in circumstances where other courts have rejected a claim, whereas the previous law permitted them to opt in.
As I said earlier, the English version not translated or not reflect the Arabic version which the law issued by.
I'm grateful for that indication.
In Arabic version, you have to read it the way around, which if that court, so generally you have a jurisdiction.
Yes.
But and you agree to opt out, and if that court reject your opt out from the original jurisdiction for this court, then you will not stay in the black hole. You have to come and fight again with this court.
I'm grateful for that.
Anyway, you can continue.
I'm grateful. My colleague just pointed out another observation which I would like to just perhaps suggest with Your Excellency, which to see if this also works in terms of the authentic Arabic. If one looks at the original provision in tab 6, 5A2 provides the parties may agree to submit to the jurisdiction of any other court in respect of the matters listed under A, B and D. A, of course, are if they're an establishment. B, of course, is whether it's agreed or performed within the DISC, or D is a matter over which the courts have regulations. Whereas if one looks, again, at least in the English, at the new Article 5 in tab 7, it is not the gateways, if you like, of a submission to jurisdiction are not made by reference to whether they are an establishment, whether the agreements are entered into or to be performed in the DISC. So in those circumstances, we would say there is a difference with respect in the provisions, and it's clear that the ability to opt out is different and in different circumstances under this agreement.
And the reason why I tell you, because on the second or the amendment one, the legislator consider exclusive jurisdiction, so
yes,
they don't add it in 2 and 3.
You actually say yes, quite exactly. So what we say, therefore, is at first we say the points I've just made, that the foundational base of jurisdiction is different, and I appreciate very much your Excellency's points on that. But secondly, we say, and this is also deeply apposite, that the judgment of the Court of Appeal made it clear in Corinth that the protection afforded by the doctrine of form non-convenience provided protection that meant that the jurisdiction was not exorbitant. And indeed, that can be seen if we look at Corinth, which is at DLA 12, as your Excellency knows. DLA 12 at page 116. DLA 12, 116. And this is the decision of the Chief Justice, at paragraph 68 at the top of the page, where he explains, the floodgates arguments submitted by the respondent can be rejected on the following grounds, most of which have been advanced by the appellant. A, it's entirely within the control of banks and other enterprises carrying on business in the DIFC and the wider area of Dubai as to whether they choose to subject their business within the wider emirate to jurisdiction of the DIFC courts. If they do not wish to do so, they can either trade through separate corporate vehicles in the DIFC and the wider emirate, or, even more simply, include jurisdiction clauses in their contracts, choosing where they allocate jurisdiction over any disputes. Now, we just had a discussion, Your Excellency, as to why we say that reasoning does not hold to the same extent now. But if one then looks at C, Your Excellency, the situation under consideration will clearly not arise where the centre of establishment is a company incorporated and carrying on business in the UAE, outside the Emirates of Dubai or elsewhere. The principles of private international law limit the powers and discretion of the DIFC courts so as to prevent the exercise of exorbitant jurisdiction, and the DIFC courts possess the discretion to decline jurisdiction on grounds of forum non-convenience. Now, the DIFC courts, as Your Excellency knows, have of course since clarified that forum non-convenience does not apply to jurisdictional disputes between the UAE courts. That's the Allianz decision, I need not take you. But we say that without these two factors, the opt-out and the forum non-convenience, we say the law as it stands, as Mr. Farha will explain in a moment, would be exorbitant, because the court in Corinth was explaining why this would not be exorbitant, but it relied on those two bases which no longer exist. We therefore say with respect, this authority is distinguishable because it's a case under the old law, and therefore this court is quite proper to look at this issue afresh and decide that Corinth does not apply in this case, which is under a different law. The second legal authority, and I'm almost finished before handing to Mr. Farhad, is IGPL itself in the Court of Appeal. This case, this decision, it's at tab 15 of the defendant's legal authorities. This case involves some, but not all, of the parties here today, and it deals with different judgments. Now, the case was heard and decided after the promulgation of the new law, i.e. the relevant amendments to Law 12 of 2004. However, we say it's noteworthy, and I'm conscious of course Mr. Abbott was obviously counsel in this case, but it's noteworthy that the Court of Appeal made no reference in the judgment to the amendments to Dubai Law 12 of 2004. And indeed, as we will show, relied expressly on the old law and authority which is no longer applicable following that amendment. The first and principal point on which the Court of Appeal, with respect we say, did not put their mind was to the effect of the amendment and the consideration of the ability to opt out. Now this can be seen, as I say, tab 15, page 164 of the judgment. And 164 here of the judgment, page 164, paragraph 123 onwards, and it says, at D, whether the parties have opted out of a DIFC court's jurisdiction, and it explains IGPL argues that should this court find Article 5A1 of the Judicial Authority Law is satisfied, a DIFC court would not have jurisdiction because the parties have opted out. Now this was discussing a concession which was made, and it explains at 125, it was held in Talim that the burden of the parties establishing that they agreed to the IFC court should not have jurisdiction was on the party so intending. Now the point there is that the court is relying on a case that predates the amendments, which is Talim, and we say is not applicable. And lest there were any doubt, Your Excellency, if one turns a couple of pages to paragraph 154 on page 168, lest there's any doubt that this court was, with respect to looking at the old law, it says 154, accordingly, we conclude that the parties had not opted out of the DIFC court's jurisdiction. To the contrary, the parties' jurisdiction agreements cover the DIFC courts and would also confer jurisdiction under Article 5A2 of a Judicial Authority Law. That, Your Excellency, is of course the old provision which we've just been discussing now. So the point, therefore, we say is that that basis of IGPL Court of Appeal decisions does not stand, because it was in fact, for whatever reason, actually addressing the old law. The Court of Appeal, however, in IGPL did turn its mind to the question of forum non-convenience. It considers on the facts of that case that the Union Supreme Court provided sufficient protection. However, we say that that reasoning is not of general application. In that case, the jurisdiction of the Union Supreme Court had already been engaged. If one turns to the decision in Allianz, that explained that forum non-convenience does not work within the UAE, whereby His Excellency Justice Madani explained it was necessary to show that the jurisdiction of the USC Court was engaged to gain protection of that jurisdictional challenge. His Excellency said that the Union Supreme Court's jurisdiction is only engaged where, and I'm paraphrasing, there are essentially two conflicting decisions. That the citation, of course, Your Excellency knows. In IGPL, the Court of Appeal does not have to consider just how high this bar was. We say that this is the only protection granted by the Court of Appeal in IGPL, which seems to say that non-DIFC UAE defendants is entirely insufficient to replace the doctrine of forum non-convenience. The doctrine of FNC, of course, can be raised immediately. The petition to the USC requires more. A defendant must challenge jurisdiction, must seek to engage jurisdiction of another court. The defendant must then bring these courts by a petition to the Union Supreme Court. Only then, Your Excellency, will this court stay its proceedings, which will have gone through many expensive stages. So therefore we say this is why the Court of Appeal in IGPL, having not considered the point, does not provide good authority that the Union Supreme Court petition provides an alternative to forum non-convenience, and accordingly that the proposed jurisdiction is not exorbitant. I should say, Your Excellency, I'm not suggesting that I'm inviting the court to somehow reintroduce forum non-convenience. A, that's not open to this court, and B, that's not my submission. My submission is, as Your Excellency knows, that the reasoning and the basis on which the IGPL decision and the Coram decision were made was dependent on these two pillars. And as I've shown, and I appreciate Your Excellency's point on the Arabic, one of those pillars is certainly starting to crumble, and the other one regarding FNC falls away. And the suggestion that because of the right to go to the Union Supreme Court is sufficient just does not avail the claimants. So, Your Excellency, those conclude my submissions. My learned friend, Mr. Farhad, will very briefly address you on why we say that this jurisdiction would be truly exorbitant, and the court should not find it.
Thank you, Mr.
Thank you, Your Excellency. Beyond what distinguishes this case with the earlier decisions which my colleague Mr. Barat just referred to, Your Excellency, today and this case is an opportunity which in our view is critical for our court and our jurisdiction to ask ourselves the question of the proper scope of our court's jurisdiction and to make sure that it is exercised in a manner that is balanced, reasonable, does not go beyond what the legislature could have envisaged when the bylaw number 12 of 2004 was adopted, and does not go against decades of conflict of jurisdiction or private international law practice around the world. I appreciate that it may be superficially pleasing for all of us as officers of this court who trust that this court is doing a good job at administering justice to expand the scope of its jurisdiction. But we should be cautious not to arrogate excessive or exorbitant jurisdiction in a manner that would trespass on the legitimate jurisdiction of other courts or on the expectations of the litigants. So I will only make very briefly 3 points, Your Excellency, for this submission. The first point that I will make is that the starting point of the rules of territorial jurisdiction, ratione loci, it's called in Latin, is that the courts of the domicile of the defendant have jurisdiction, not the courts of the domicile of the claimant. That is the case in UAE.
Which you refer to the CPR, Civil Procedure Law, UAE Civil Procedure Law.
Correct, Your Excellency. Article 31.3 of the UAE Civil Procedure Law provides exactly this. I can read it out loud for the record. In commercial matters, jurisdiction shall be vested in the court in whose area the defendant has his domicile, etc. That is the case also in the EU, Your Excellency, where there is an EU regulation 1215 of 2012, which provides the same rule, Your Excellency, between EU member states and gives jurisdiction to national courts of the defendant's domicile. And, Your Excellency, there is an important policy reason why that is the case. That is the case in the interests of justice, of good administration of justice. That is the case because legal systems around the world, including the UAE legal system, or the legal system in my home jurisdiction in France have considered that the claimant should not obtain a home advantage, and the trouble caused to the defendant to defend against a claim which, when it is commenced at the very least, is obviously not yet proved, should be limited. It would therefore be, Your Excellency, an extremely unusual situation if our court departed from these decades of legal learning and practice to give a home advantage to a bank, an organization which by definition, unlike, for example, consumers, which may need consumer protection, does not require specific protection. The interpretation of the statute which our learned friends propose would be extremely unusual. In our submissions, it creates an expensive jurisdiction based on the minimal presence of a claimant in our jurisdiction. It is also, I should add, particularly inappropriate in this case because the DIFC is itself a distinctive jurisdiction in the UAE. The DIFC courts apply common law, use English language, which, for example, for my clients is a foreign language. And all of this applies specific rules of procedure. All of this speaks, in our view, Your Excellency, in favor of making careful and considered decisions on jurisdiction, because there is a real danger of injustice where unwilling or unprepared parties are pulled by a claimant into a court system that they do not understand and which they do not expect. The second point, Your Excellency, is that the respondent says today that this court has jurisdiction under Article 5A(1)(a) of the Bylaw No. 12 of 2004 because, according to the respondent, the entirety of Standard Chartered Bank should be considered an establishment of the DIFC because it has a branch license in the DIFC. According to the respondent's interpretation, it does not matter what the reality of the parties' relationship was. It does not matter that it had closer connections to another jurisdiction. It does not matter that the parties could not have envisaged that their dispute would be brought in the DIFC court. The only thing that matters is that, according to the respondent, the only thing that matters is that a DIFC branch, however irrelevant to the case we are dealing with, exists. We say this cannot be right, Your Excellency. If one follows the respondent's logic, Standard Chartered Bank can sue any of its counterparties before the DIFC courts, no matter which part of the world the particular transaction in dispute arises out of. So, following the respondent's interpretation of the statute, a Chinese party, Your Excellency, for example, with a home loan agreement from this bank in Beijing with no connection to the DIFC could one day sue the bank in the DIFC or be sued by the bank in the DIFC. And we say that would be exorbitant if a Chinese court, for example, applied the same logic, an Emirati party with no connection to China would have to go and defend himself before Chinese court because a branch of the entity exists in China. The correct position, Your Excellency, which is our interpretation of the law, which we think is more reasonable, narrower, is that a gateway to the court's jurisdiction over legal entities, including branches of legal entities established in the DIFC, exists under Article 5A(1)(a), to the extent the DIFC branch takes part in the underlying transaction or dispute. Therefore, we say there must be an assessment whether the DIFC branch was involved or not. The third and final point, Your Excellency, we make in this regard is that our interpretation of the statute is both narrower and more reasonable. And it does not prevent parties contracting in the DIFC's jurisdiction if they wish. There is no limit to that. And I see no reason, for example, in this case, why the bank, which in this case drafted all of the transaction papers, could not have inserted a specific clause to that effect. It did not. And it is for the bank to explain why. Our interpretation does not interfere with the DIFC court's oversight over the part of the legal entities that are registered and operate within the DIFC, to the extent, Your Excellency, those parts are really involved in a party to the dispute. Nor, Your Excellency, is our interpretation inconsistent with logic. If you turn to Article 5A1, which you will find the defendants of the Dubai law, which number 12 of 2004, which you will find at DLA 8. We will see that a similar analysis of the nexus to our jurisdiction is necessary for all the other grounds of jurisdiction. So if you take, for example, 5A1B, civil or commercial cases and claims arising from or relating to a contract or a promise to contract, whether made, concluded, or executed in whole or in part in the center. If you take the next provision, civil or commercial cases and claims arising from or relating to an incident or a transaction accomplished in whole or in part in the center. So, in each case, there is an analysis of the connection with this jurisdiction, and we say the same should be true of the case of Article 5A1A. The court, there's no reason why the court could not investigate whether the claimant or defendant said to be the establishment is being sued in relation to the part of the entity that is established in the DIFC. It's not a more difficult exercise than the investigation which the court has to conduct in relation to the other provisions in this law. Such an inquiry does serve, however, the purpose of eliminating the circumstances where the DIFC courts can seize jurisdiction over unwilling parties who have done nothing. That would lead a neutral observer to suggest that they had acquiesced in circumstances that would indicate that agreement to fall within the jurisdiction of our court. And therefore we say our interpretation, Your Excellency, creates a reasonable interpretation of the statute and does not create an exorbitant jurisdiction as would our learned colleagues' interpretation.
Thank you. You need to take a break 5 minutes? And
Yes, Your Excellency.
so we'll come back within 5 minutes. Yes, Mr. May I request you, before you proceed, let's go back to the facility agreement and define them.
The facility agreement.
Yeah, facility agreement and pledge agreement.
Which facility agreement, Your Excellency? Because there's a number of them.
Which is under dispute.
Well, the claim is under. There's a number of facility agreements that have been named in the claim form. The latest one is the 8th of April 2012, but there are a number of previous versions as well.
Which bundle? Authority bundle would be?
If we go to Hearing Bundle Volume 2, tab A7. I can take you through briefly the various agreements, if that will assist.
So, actually it's 231, which I defined it before.
Yes, 231, that's the what I call the first loan agreement dated the 2nd of August 2009. But then there's a number of other agreements that followed that.
And the second one would be?
The
In total,
one,
how many agreements in total?
there are another 3 agreements, Your Excellency, plus the guarantee as well. They're all in the same bundle, so I can take you to them now if you want.
Yeah, please.
So the second one is at 363. dated
Yes.
the 25th of May 2010.
Can I consider this as a number one?
Sorry, I'm being reminded there's an earlier.
Okay, sorry, number two still.
Okay, yep. There is an earlier agreement, Your Excellency. Forgive me, it's in a different bundle. I'm going to have to take you to Hearing Bundle Volume 2, tab A4, just to get the chronology right.
Bundle two?
Bundle 2, tab A4.
Yes.
At A213. You'll see there's a facility letter there dated the 12th of May 2010.
Then this will be number two.
Number 2, yep. And then if we go back to where we were before, sorry, Hearing Bundle Volume 2, tab A7. So I was just showing you what is actually Loan Agreement Number 3, dated the 25th of May 2010. And that's at page 363. Do you have that, Your Excellency?
This will be number three.
And number 3, yeah, and whilst we're there, it may be worth taking you to the contact details provision in that agreement, because it is the agreement that sets out the contact details, and that's at page 371. If you turn to page 371 in that document, at the top you'll see a number that says 6.2 contact details for the borrower Falloil and for borrower 3 IGPL, and the right hand side you'll see a telephone number, a fax number and an email, subair@falloil.co.ae. I thought I would just show you that whilst we're in this document. Then the next facility agreement, number 4, is at page 375. Dated the 22nd of November 2010. And the last facility agreement for Falloil is at 378. Dated the 8th of April 2012.
And all of them, Mr. Majid, is guarantee.
And then we'll go to the guarantee, which is at 461. You'll see 461 guarantee all monies. 462.
Give me a second, please.
Sorry.
Yes, this is
461 is the front page of the guarantee. and then you'll see on 462 462 at clause 2, headed guarantee, in consideration of the bank providing banking facilities, and banking facilities is defined above as such facilities or other accommodation as the bank may make or continue to make available to the customer. So it's may make or continue to make in the future. And that's what Mr. Al-Sari is guaranteeing at clause 2.1. IGPL is guaranteeing at 2.11. And you'll see on page 465 the guarantee on behalf of IGPL has been signed by Majid Al-Sari. Is that helpful? Okay. Your Excellency, we are making 5 outline points in response to this application. My colleague, Mr. Jury, is going to address you on the jurisdiction points, but I will address you first on the alternative service order. The 5 points, in summary, that we make are, first of all, that these courts have exclusive jurisdiction over this claim in accordance with Article 5A1A of Dubai Law Number 12, as Standard Chartered Bank is a DIFC establishment. In addition, this court has exclusive jurisdiction under Article 5A1B of the Judicial Authority Law, given that the agreements between the parties were at least partly concluded, finalised or performed within the DIFC. Secondly, we say it is immaterial that some of the parties' agreements predate the amendments to the Judicial Authority Law, as the amended JAL has been confirmed to have retrospective effect by this court, and in any event, equivalent provisions conferring jurisdiction on the DIFC courts in these circumstances have existed in the Judicial Authority Law at all times. Thirdly, we say there has been no opt-out of the DIFC court's jurisdiction, and that's what my learned friend has to show, let alone a clear and express agreement to opt-out. Fourthly, we say the defendants have both conceded that these courts, DIFC courts, have jurisdiction over this claim. And finally, we say that the alternative service order is not defective and should not be set aside. So I will deal with the alternative service order, and I think it's important for the court in my submission to bear in mind the overarching context to why this order was necessary and this claim in general, and that is, as we shall see from the factual information available, the 2 defendants here are deliberately evading service. It's as simple as that. That is the reason why we are here today. That is the reason why the alternative service order had to be made in the first place. I will deal with 3 points. First of all, the alleged technical defects in the alternative service order. Secondly, in my submission, there was a good reason to order alternative service. And thirdly, in my submission, there was a good reason for the methods of service that were ordered. Turning first of all to the alleged technical defects in the alternative service order. In my submission, it is important to have in mind that the DIFC courts have already confirmed in the set-aside judgment that the claim, both the claim form and by extension therefore the alternative service order, which was served at the same time, have been successfully served on the defendants by email in accordance with the terms of the alternative service order. And if I can just take you to that order quickly, it's in application bundle 1. at tab 15, page 91. And you'll see in particular at paragraph 4, it says the respondent contends that whilst it's unnecessary for it to establish actual receipt of the claim by the defendants, and that's because, as Your Excellency will no doubt recall, the alternative service order provided that there would be good service purely on sending the emails, not receipt. In any event, read receipts were received in respect of the emails sent to the applicant, and the witness statement of Ms Hambley is relied upon in support of this argument. Paragraph 5. I am not satisfied by the applicant's assertion that service of the claim form was not properly served, and am persuaded by the respondent's arguments in this regard. So the court has already found that the claim form has been properly served on the defendants here. That order, or that part of the order, has not been appealed by the defendants. I'm afraid I'm going to have to take you to a couple of documents which will show you that both defendants were clearly aware of the existence and contents of the claim form, both when this was served in accordance with the alternative service order in November 2016, but also on at least 2 occasions prior to that. So if we can go to volume 3 of the application bundle. Tab A12. Starting at A326. And these are the emails and the covering letters, which we shall see in a minute, that were sent by my firm in accordance with the alternative service order to addresses at both Falloil and IGPL. You can see that the emails were sent in 2 parts because of the size of the emails, so there's actually 4 emails, 2 emails each to each defendant. And then at A330 we have the emails to the Squire Patton Boggs addresses, and A331. Squire Patton Boggs of course have confirmed that they received the claim form, and in fact have also confirmed that they sent this on to IGPL. And then at A332 and A333 we have the letters, the covering letters that accompanied those emails, which attached the alternative service order and the claim form and the DRC court case plan. If you have a look at A333, I would draw your attention, because I'll come back to this, to the address for Investment Group Private Limited, which is Fowl Building, Sultan Al Awal Street, Leia, PO Box number 3755. I'll come back to that in a minute. It is clear both from the documents that were served and the subsequent finding of the court that the claim form, that both defendants are clearly aware of the claim form. Actually, whilst we're still in this bundle, I should take you to the read receipt at A362. That was obtained from Mr. Al-Sari. That's A362 to A365. And you can see that email was read on the 2nd of November. You may recall from Mr. Jury's witness statement that no read receipt to these emails was received from Mr. Subair or Mr. Abdul Karim, but also no bounce back was received. And as we shall see, previous emails sent not much before this date to Mr. Subair and Mr. Abdul Karim were read, and we do have read receipts for those emails, which I will take you to shortly. So my submission that That's important to bear in mind when dealing with the alleged technical defects in the alternative service order. Dealing with the two defects that have been identified by my learned friend, it is our submission that there was no requirement in the alternative service order to serve the application notice, and you have my submissions on that at paragraph 30 and 31 of my skeleton. But even if there was, without prejudice to that position, we say that this is an alleged procedural order which the court quite simply has the general power to correct under RDC 4.51. And Your Excellency will be familiar with RDC 4.51. I won't take you to it, but it's a tab 23 of the claimant's bundles on page 458. Your Lordship.
Yeah, I have the...
Do you have it? It's headed General Power of the Court to rectify matters where there has been an error of procedure, where there's been an error of procedure such as a failure to comply with a rule or practice direction. 1, the error does not invalidate any step taken in the proceedings unless the court so orders, and 2, the court may make an order to remedy the order. My learned friend took you to the English authority of Integral Petroleum to try and make the submission that this power was somehow narrower than it is made out to be. I'm afraid I'm going to have to take you back to that authority, so that's in the claimant's legal authorities. At tab 6.
Page?
Claimant's legal authorities, tab 6.
Yeah, so it's
Page 124. And you may recall that he read you at least the first 2 sentences of paragraph 37, which is to the effect that this case is not concerned with service of originating process, but service of particulars of claim, and he then tried to distinguish this case from that. But of course, we are dealing with service of an application notice here, not service of originating process, in other words, a claim form. The claim form, as we have seen, was served and did come to the attention of both defendants. Even if we were dealing with service of a claim form, he didn't read you the 3rd sentence, which starts, Phillips versus Nussberger indicates that even for service of originating process, the rule is to be given a wide effect. And that is so where the application of the rule affects the establishment of an in personam jurisdiction in one of 2 competing jurisdictions. So it's quite clear that the rule, and it's a sensible rule, in my submission, has a wide effect. The 2 defendants and the appellants here are advised by professional solicitors who have been able to obtain copies of the application notice. The order itself referred to the application notice. There can be no question that the claim form has been properly served on both defendants. And in my submission, the appellants have not identified any prejudice whatsoever that they have suffered by the alleged errors, either in their skeleton or elsewhere. This morning, my learned friend appeared to say that the prejudice suffered was the inherent right, their inherent right to challenge the alternative service order. At the risk of stating the obvious, that's what they're doing today. So we're in the same position. No prejudice there. Just in terms of the power under RDC 4.51, your Lordship will be familiar with a case in which your Lordship gave judgment, which is cited at paragraph 37 of my skeleton, DIFC Investments, where this court recognised the significant power to remedy procedural defects, and that's at paragraph 37 of my skeleton. And in that case, Your Excellency found that the DIFC courts determined that the court's power to remedy procedural defects should be properly exercised where neither of the parties has been prejudiced in the proceedings. That's the case here. Well, we certainly say that's the case in relation to the defendants. And furthermore, no additional delay should be allowed due to the simple procedural defects. So we say the court has the power to deal with any alleged procedural defects of its own accord. Turning to relief from sanctions, my learned friend took you at some length to the relevant CPR provisions dealing with relief from sanctions, and I'll have to take you back to the same document. It's the standalone handout you were given this morning.
Yes, it's before me.
And if you turn to page 113, you'll see there's a heading, the importance of discouraging opportunism by the non-defaulting party. And this is the Court of Appeal in Denton. The second sentence. Rule 1.3 of the CPR provides that the parties are required to help the court to further the overriding objectives. Parties who opportunistically and unreasonably oppose applications for relief from sanctions take up court time and act in breach of this obligation. The court made it plain that it is wholly inappropriate for litigants or their lawyers to take advantage of mistakes made by opposing parties in the hope that relief from sanctions will be denied and that they will obtain a windfall strikeout or other litigation advantage. And in my submission, that is precisely what is happening here. Whilst we are still in this document, I would also take you to page 115, and there's a heading there, matters of form, not substance. And you'll see the first sentence says, a mistake of form rather than substance is one of the examples given in Mitchell of a case where the non-compliance can be regarded as, in Denton parlance, neither serious nor significant. So in my submission, if there has been any alleged mistake here, it is clearly a mistake of form rather than substance, as both defendants have seen and received the claim form. They subsequently saw the application notice, and they are here today seeking to set aside the order. So in my submission, looking at the Denton tests, the alleged error was a mere procedural error and was neither serious nor significant. It was not intentional. And thirdly, the defendants have shown no prejudice that has been suffered by any alleged error. They can still apply to set aside the order. And in fact, that is what they're doing here today. By contrast, it would be extremely prejudicial to my clients were the order to be set aside, because they would have to go through the time and cost of reserving the claim form in circumstances where both defendants have clearly been served with the claim form and have knowledge of the claim form. To my learned friend's point about the lack of application for Denton relief, in my submission, the court has power under RDC 23.32 to dispense with an application notice, and we say that is warranted in these circumstances where all the evidence is already on the record. We are dealing with the interpretation of the alternative service order, that's on the record. We are dealing with the attempts that were made to serve the alternative service order, that is already on the record. In my submission, prejudice for failure to serve a document is only really relevant to orders having a real prejudice, such as a freezing order remaining in place without the defendant's knowledge. That is not the scenario we are in here. Just dealing quickly with the second alleged defect in the alternative service order, the failure to include a statement of the appellant's right to set aside the order. I can make the same submission on that point. The claimants have applied to set aside the order. Quite simply, they are here today applying to set aside the order, so there can be no prejudice that has been suffered by them as a result. And it's probably worth taking you to one of the authorities my learned friend referred you to, which is the White Book commentary on the same provisions in the CPR. So if I can take you to that, just to give it some context, that is the defendant's legal authorities at tab 5. Page 41. And this is the section of the CPR dealing with CPR rules 23.9 and 23.10. CPR 23.9 is the mirror rule of RDC 23.93. If you look at page 41, 4 paragraphs down, there's a paragraph that begins, Interdorian Group International versus Sims. And I'll read this. An order releasing the claimants from an undertaking not to seek to enforce a freezing order abroad was made in the circumstances described in 23.91. The order did not contain any term releasing the claimants from the obligation imposed by 23.92. 23.92 is the mirror rule of RDC 23.931, which is the obligation to serve the application notice. And they did not comply with those obligations until enforcement proceedings in the foreign jurisdiction were commenced. Further, the order did not contain the statement required by 23.93. CPR 23.93 is the mirror rule of RDC 23.932, which requires the statement of the other party's right to set aside the order. So quite similar circumstances, certainly in relation to the second element. We wouldn't accept the first element. And then the commentary continues. In dismissing the respondent's application to restrain the foreign proceedings, the judge said that, although it is not open to parties to flout CPR provisions, the court must retain a sense of proportion in deciding what should be the consequences of a failure to comply with the rules. In the circumstances, the claimant's breaches of 23.9 were technical and did not justify setting aside the permission to enforce dismissing the respondent's appeal. Now, my submission, which I don't accept, there were procedural issues with the alternative service order. They were purely technical and do not justify setting aside the alternative service order. Turning to my second point, my second submission, that there was a good reason to order alternative service. It's important in my submission to bear in mind what the requirements are to obtain an order for alternative service under the RDC. And I'll just take you briefly to that. It's in the claimant's legal authority. The claimant's legal authorities at tab 23. Page 465. RDC, you'll see RDC 9.31, where it appears to the court that there is a good reason to authorise service by a method not permitted by these rules, the court may make an order permitting service by an alternative method. And then at 9.32, An application for an order permitting service by an alternative method, 1, must be supported by evidence stating A, the reason an order for an alternative method of service is sought, and B, what steps have been taken to serve by other permitted means. So that's the test that needs to be satisfied. There's no wording such as substantial, which my learned friend uses in his skeleton to say that there had to be substantial attempts to serve. That wording doesn't appear in the relevant RDC rules. Dealing with a couple of the issues raised by my learned friend, he has produced no authority for the proposition that the bank had a duty to provide evidence of the law concerning service in charge. That's just a bare proposition. As I said, there's no requirement under the RDC to have made substantial efforts to serve. There is also no requirement for the applicant to show that it has exhausted all permitted methods of service. As we have just seen, RDC 9.31 simply requires a good reason for permitting service by an alternative method. And it's probably the time to go to the Abila decision, which is relevant to this question, and that is in the claimant's legal authorities. This is a decision that gave some indications as to what a good reason for ordering alternative service was.
On which tab?
That's in claimant's legal authorities, tab 12. It's also an authority relied on by my learned friend in his skeleton. It's a case dealing with a retrospective declaration of alternative service in Lebanon. So it's a case dealing with service of proceedings out of the jurisdiction under the relevant rule under CPR 6.15. And it's a decision by the Supreme Court of the UK. And if you look at paragraph on page 248, paragraph 33. They're discussing here the equivalent CPR rule, which is CPR 6.15, which reads 6.151 reads, where it appears to the court there is a good reason to authorise service by a method or at a place not otherwise permitted by this part, the court may make an order permitting service by an alternative method. You'll see at 33, in the third sentence, I do not think that it is appropriate to add a gloss to the test by saying, and that's the good reason test, by saying that there will only be a good reason in exceptional circumstances. So exceptional circumstances are not required. And then if we look down at paragraph 36, at the bottom of the page, the mere fact that the defendant learned of the existence and content of the claim form cannot, without more, constitute a good reason to make an order under Rule 615(2). On the other hand, the wording of the rule shows that it is a critical factor. Now, I accept that the wording of 615(2) is not mirrored in the RDC, but in my submission it is still an important factor that the defendant learnt of the existence and content of the claim form. And we can see that if I take you back to the bottom of paragraph 33, sorry, that's page 248. It seems to me that this is the last sentence of paragraph 33. It seems to me that in the future, under Rule 615(2), in a case not involving the Hague Service Convention or a bilateral service treaty, which is this case, the court should simply ask whether in all the circumstances there is good reason to order that steps taken to bring the claim form to the attention of the defendant is good service. And then, whilst we're here, just quickly turning over the page 249 to paragraph 39, the second factor that they considered as to whether there was a good reason to order alternative service dealt with cooperation of the defendants. The second sentence of paragraph 39 reads, "Furthermore, the judge noted that the respondent was unwilling to cooperate with service of the proceedings by disclosing his address in the Lebanon. While I accept the submission made on behalf of the respondent that he was not under a duty to disclose his address, his refusal to cooperate does seem to me to be a highly relevant factor in deciding whether there was a good reason for treating as good service the delivery of the documents in Beirut within 6 months of the validity of the claim form." And as you'll see in my submission, both of those factors are present in this case. So what we take from that case is two key issues to consider in determining whether there's a good reason to order alternative service is, one, whether the existence and content of the claim form had come to the attention of the defendants, and two, whether the defendant had refused to cooperate by providing an alternative address for service.
Mr. James, sorry to interrupt you, but just a recall from memory, there is a letter from the IFC court registry to Dubai court registry. Then there is we call it a legal deputation from Dubai court to Sharjah.
Yep.
Do you have a reply from Sharjah court?
We have the letters that were sent. They are, I think, exhibited to...
And again, I recall from memory, I saw that letter, and Sharjah court exists their efforts and try to find an address, and they fail, and they submitted before me to grant or to issue.
Exactly correct. I can take you through the attempt. I think it's important that you see the attempts that were made, I'm afraid, before you ordered the alternative service order. But the detail is set out in the witness statement of Victoria Hambley, which I won't obviously read in its entirety now, but I can give you the reference. It's at Volume 3, Bundle A1. It might be useful to have it open whilst I take you through these documents. Sorry, it's Volume 2, Bundle A1. Tab A1. I can just take you to the point that you raised, which is if you go to page A03, you'll see at paragraph 8 there's a discussion about in order to effect formal service in charge, I sent a letter to the DIC court registrar requesting the court to issue a letter to the Sharjah court. That was done. That was then sent to local council in the UAE. And then we arranged, paragraph 10, for the Sharjah Court bailiff to attend on several occasions the respective addresses of FAL and IGPL. That's paragraph 10. Then you'll see at paragraph 11, Mr. Bajamal, that's local counsel for SCB, informed me he'd been informed by the bailiff that the first bailiff attempt to serve the claim on FAL had failed. FAL no longer operates from the premises. Similar in relation to IGPL in the next sentence, because the address now houses a company called Horizon. And then the Sharjah Court bailiff recorded the result by return letter to the DIFC court. That is in the bundle. If you need the reference, I think it's A166. And then an alternative physical address for IGPL had been identified, and a similar process was attempted for that with a similar result. Paragraphs 12, 13 and 14, a similar unsuccessful attempt was attempted through the Sharjah bailiff.
Sharjah bailiff, they use DHL facility?
The Sharjah, DHL was used separately by us as another attempt to serve them. I'm not aware of what method the Sharjah bailiff uses. I think they attend personally. They attend personally at the premises because they obviously have to verify who is there and who isn't. That's set out in the witness statement. They attended personally. Okay. I've given you one of the references for the Sharjah court letter A166 in Arabic. The other one is A157. And then you'll see that, are you still in Miss Hambley's witness statement? You'll see from paragraphs 15 to 17, an attempt was made to serve the claim form and the case plan by courier, and that was initially received by both IGPL and FAL, and then somewhat curiously returned 2 days later. And I'll take the document with a notation that please note that Mr. Majid is not with his company and receiver did not know the above person. The address that was delivered to is important because the very same address at which we were told Mr. Majid was not with the company is now being used by both defendants in the onshore Dubai proceedings. So the address that we were told the defendants were not present at is now being used by both of them in the Dubai onshore proceedings, and I'll show you that from the documents.
Actually, it's written in Arabic. The secretary refused to receive the document.
Are you reading the Sharjah court letter?
Yes.
Yes, yes.
And the bailiff, he went twice.
The bailiff went to both premises on the 19th of June. That's paragraph 10 of Miss Hambley's witness statement, and then he went again on or around the 26th of September, and that's paragraph 14 of Miss Hambley's witness statement.
Yeah, it's clear for me.
Okay, can I just? But it's important that I show you some of the documents showing the documents that were sent and the emails, and they are at. Still in the same hearing bundle, tab 2. Tab A2. If we go to A12, we've seen this before. This is the letter that was sent by email, fax, and courier attaching the claim form. So that's to FAL. Same letter to IGPL as at A34. The covering emails that accompanied those two letters are at A64 and A65. So this is the 12th of May letter. Delivery receipts are then at A66, A67, and then at A68 we have Mr. Al-Sari's read receipt. A68 and A69, two read receipts because there were two letters. And you'll recall that we didn't get a read receipt on this occasion from Mr. Zubair or Mr. Kareem, but we didn't get a bounce back either. So that's the 12th of May 2016, and then a further attempt was made on the 18th of July 2016 at service. That is in the same bundle at A75. A75 is the foul oil letter, and this is an important letter. It refers in the second paragraph to previous attempts to send copies of the claim form and the case plan, and an attempt to effect service with the Sharjah bailiff. Then in the fourth paragraph, we should be grateful for your confirmation of a suitable postal address for service of the claim, or in the alternative, your agreement to accept service of the claim by email to the above-mentioned email address. In the event that FAL fails to provide an address for service and does not agree to accept service by email, the only logical inference is that FAL Oil is deliberately evading service of the claim. We will bring this to the DIT court's attention, and then in the final paragraph, we foreshadow the alternative service application. In the event we do not receive a positive response, we will make an application for an order for alternative service. And the same letter was sent to FAL, and that's at to IGPL, and that's at A99. Again, you'll note the address: FAL Building, Sultan Al Awal Street, PO Box 3755. No response ever received to those letters. So you recall from the Abila case, request for an alternative address or contact details, no cooperation. The fact that those emails, that those letters were read and received is evidenced by the read receipts, which are at A127. In fact, first of all, at A123 to 124, you have the covering email. And then delivery receipts at 125, 126, and then at 127, A127, you see in this instance we do have a read receipt from Mr. Abdul Karim at IGPL, dated July the 19th. And then at A128, we have a read receipt from Mr. Al-Sari. And A129, another read receipt because he was sent both letters. And then, importantly in this context, at A130 and A131, on the 19th of July 2016, we got a read receipt from Mr. Saber's email address for both letters. You recall Mr. Saber was the name that we saw in the loan agreement. He's the gentleman who's said to have left FAL in 2015. Some 18 months later, we are still getting a read receipt from his email. Obviously, the bank is not a detective, but it was clear that the email address was being read as late as July 2016, which was only several months before the application for alternative service. We just before we leave these documents, we briefly touched on the attempt that was made to serve these documents by courier as well, and the initial receipt and then the return. Just so you have them for the record, Your Excellency, the initial evidence of delivery is at A56.
Say it again, the page number?
A56. So this is the original letter of the 12th of May attempting to serve the claim form. And you'll see at the top it has a Weibull number, Saturday, May the 14th, 2016, 11:13, and there's a number 9, delivered, signed for by someone called Muhammad Ali Ahmed. And then over the page, A56, this is proof of delivery. And again, a signature. And then for the second letter, A58, also delivered on Saturday, May the 14th. Item number 9, signed for by Mohammed Ali Ahmed in Sharjah. And A59, the proof of delivery. And then, as I mentioned, 2 days later, at A60 and A61, we get the "we don't know who Mr. Majid is" message. The documents having been with them for 2 days. One of those documents, at least, was delivered, as we've seen from the letters, to an address at Sultan Al Awal Street, Al Laya District, PO Box 375. Perhaps if I can take you to one of the new tabs that was put in yesterday, tab 22, which is in bundle 1. We can come out of this bundle now.
So the court judgment?
It's an application, as I understand it. Well, I'm looking at the English version on page 207, I'm afraid, but there is an Arabic version behind it. Do you have page?
I have page 184.
Okay, we need 207.
207. Yes.
This document, as I understand it, as we can see from the title down the bottom, is a request by the two defendants in this case before the Dubai court for an request for an appointment of an expert. I'm told it's dated the 27th of December 2017. The date may be in the Arabic. I can't see it in the English. The important point I'm making here is the two addresses relied on by both plaintiffs, and they will look familiar to you because they are the same address where we attempted several times to serve the claim form, and we were told no one at the building, Mr. Majid doesn't exist here. And now, a year and a half later, they're using the same address in the Dubai court proceedings. Clear evidence in my submission of an intent to evade service. Just dealing very quickly with one point raised by my learned friend.
Sorry, Mr. Judge.
Yes.
Yes, I noticed that this case is filed before Dubai court
That's correct.
to appoint an expert.
That's correct.
Okay, and this case is still going on.
Yep, as far as I understand,
And the same subject or is it different subject?
it's the same subject. We have challenged the jurisdiction, as you would.
I'm not surprised if the next move will be JJC.
I don't want to put any ideas into the defendant's head, but no comment. But these proceedings are still ongoing, and we, obviously, the bank, have challenged jurisdiction, and I understand the next hearing is on the 29th of May 2018, so hopefully that helps complete the picture.
And that request is to stay the proceeding before Dubai court until the outcome of today's hearing?
There's no request for a stay as far as I can see. I think from the title on page 207, it's a request for appointment of an expert to settle the account between the plaintiffs and the defendant and determine that the plaintiffs do not owe the defendant bank any debt. I'm guessing, but we've seen this argument before, the defendants will be saying we don't owe the plaintiffs any money, and in fact the plaintiffs owe us money. The plaintiffs in this case, that is.
But in others saying you don't apply for a stay before Dubai court.
I'm not, well, my learned friend may correct me, I'm not aware whether my learned friend has applied or his clients have applied for a stay. As far as we're aware, they have not applied for a stay before the Dubai court. And we have challenged jurisdiction. Just dealing with one point raised by my learned friend in relation to the civil procedure code provisions as to service, and they are contained in the defendant's legal authorities.
Switch tab.
Tab 17. Your Excellency will be familiar with these provisions, in particular Article 8 dealing with the notification requirements, and Article 9.2 the requirement to notify, in terms of a private company, their administrative centre or their legal representative. Well, of course, that's what we tried to do, and we were told, the Sharjah bailiff was told, that there was no one at what we believed to be their administrative centre or their legal.
But again, this proceed before UAE
Precisely.
court except the IFC. So
Precisely. So this is the onshore procedure. But my learned friend is trying to make a point that we did not, for example, attempt to serve the alternative service order by a notice in the press. My answer to that is, well, that's an alternative service method in Sharjah. Secondly, was not required to show good reason under the DIFC court rules for alternative service under RDC 9.31, where the defendants are deliberately evading service. It would have served no purpose in this case because there was no one apparently at those.
I can understand the point which Mr. James coming from, which is a partner in the service is supposed to use the method which the place you want to serve. But
I'll come on to that in a minute.
Unfortunately, or fortunately, I don't know which one is you prefer. Here, the Article 7 of the JAL or Judicial Authority Law give us a window through Dubai Court. So our power ended with the Dubai Court. What's happened between Dubai Court and other Emirates Court, we cannot interfere with.
Precisely. Thank you, Your Excellency. Well, on that point, I'll move on to deal with in a minute the point that you've just discussed, the methods of service. Just before we've got to that, I would make the additional point that even under the civil procedure law, service by email is possible under Articles 8 and 9. And under Article 8, service by the press is only in the case where there is no email address available. And of course, there was an email address available here. So we say that service in the press was not required. Moving on, just to deal with one point made by my learned friend as to the alleged failure of the bank to make inquiries as to the names and addresses of the relevant individuals at the bank. That was actually the defendant's obligation under the relevant facility letter, and that is at, if I take you to the witness statement of Mr. Swami, that is in volume 3, tab A13. And it's page A466. Bottom of page A465, paragraph 18. And this is where Mr. Swami said the onus of notifying any change of contact details is on the defendants, the borrowers, and you'll see this is part of the master credit terms. The address and fax number of each party for any communication or document, this is the top of page A466, in connection with the finance documents will be as stated in clause 6, which is the clause I showed you earlier, with the email address, or is otherwise notified to the other party by not less than 5 banking days' notice. So there's an obligation on each party to notify the other party of any change of address. So the obligation is not on the bank to be a detective. Just 2 more points before I hand over to my friend, Mr. Jury, dealing with the point that you just raised, Your Excellency, the method of service. In my submission, there was a good reason for the method of service that's ordered. I'm at paragraph 60 of my skeleton. The defendant's argument seems to be that RDC 9.54 and 9.55 require service to be effected in accordance with the laws of the place of service, in other words, Sharjah, and therefore any method of alternative service permitted under the courts must also be lawful in Sharjah. This is to conflate 2 different rules in my submission. RDC 9.54 and 9.55 are the default rules that prescribe the method for regular, if that's the right word, service out of Dubai. And those SCB attempted those rules, but they were ineffective, which is precisely why the alternative service order was made. Otherwise, there would be any alternative service order would be odious. There would be no reason for having an alternative service order. And it's quite clear from the authorities that provided that the method of service is not illegal in Sharjah where service is being effected, this is paragraph 61 of my skeleton, it may constitute good service if ordered by way of an alternative service order. So there's no requirement for that method of service to be a method which is ordinarily permitted for service under the laws of the jurisdiction where service is effected. And there's a quote at paragraph 61, again from the Abila case, and then I'll apply that to the facts of this case. And I would draw your attention to, this was dealing with service of a claim form in Lebanon, to the last highlighted sentence. Although it was held that delivery of the claim form was not permitted service under Lebanese law, it was not suggested or held that delivery of the documents was contrary to Lebanese law, or that an order of an English court that such delivery was good service under English law was itself contrary to Lebanese law. And you'll see from 63 that the same reasoning applies to this case. We say it's irrelevant whether service by email is effective service in accordance with Sharjah, but as we've seen, it is in any event. Sending documents to an email address is not illegal in the UAE. And an order of the DIFC courts that such delivery was good service under DIFC law is not itself contrary to UAE or Sharjah law. And in any event, under RDC 9.12, the DIFC court has some freedom as to methods of service. It has the freedom to order otherwise in respect of any of the requirements for service in RDC Part 9. If I can just take you quickly back to the civil procedure law. I know we had the discussion as to that is the other side of the fence, as it were, from the DIFC courts, but a couple of points to make in relation to this point, particularly in relation to email service. So that's in the applicant's authorities bundle.
Tab 17?
Tab 17, yeah. Page 196. You'll see from Article 8.1 that service by email is possible. Also under Article 8.4. And if you turn over the page, Article 10.3, from the date of service by the registered email with mail with acknowledgement of receipt by fax or email. It's also worth noting, whilst we're here under Article 13, that Article 13, second sentence, if the purpose of the procedure has been achieved, the nullity shall not be decided in spite of a stipulation thereon. In other words, if the claim form has existence and contents of the claim form, even on shore, has come to the attention of the party, then it won't be declared a nullity, except as Article 14 says in cases of public order, but I would also draw your attention to Article 14.2. So, save in cases relating to nullity by reason of a public order, 1 is not relevant. 2, a party who has been instrumental in it may not rely on it. And that is precisely what we are saying here. They have been instrumental in evading service. I've nearly finished, Your Excellency. I've taken you through all the emails, and it's quite clear in answer to my learned friend's submission that there was no reason for us to send the service, the claim form and the alternative service order to those emails, that there was very good reason to do so. That's set out at paragraph 66 of my skeleton. We had received read-receipts from these emails only shortly before, and it's not for the bank to try and guess who they should send this to. Finally, this is paragraph 68 to 70. Without prejudice to our primary of my skeleton position that the alternative service order is not effective, in the alternative we submit that the court can dispense with the requirement for service of the claim form under RDC 9.34. And although we say you don't even need to go there because the alternative service order is valid, without prejudice to that, this is a clear case where service should be dispensed with, where the defendants have been on notice of the claim for many, many months. The purpose of service has been achieved. The defendants have shown no prejudice, and setting aside the alternative service order will only serve to delay the ultimate service of the claim on the defendants and will not put them in any better position. Forgive me, Your Excellency, I've taken a bit longer than I wanted, but I think it was important to go through the documents. My colleague, Mr. Jury, will address you on...
It's okay, fine for me, unless if you want to break, have a lunch, because I'm fasting, I don't have a...
I understand, Your Excellency.
And shall we come back at 2? I don't mind.
With your permission, Your Excellency, yes, I think...
So,
given the circumstances. My apologies for taking
it's okay, no problem. We are here. So then we'll adjourn until 2 o'clock. We'll start again at 2 o'clock.
Thank you.
Yes, Mr. James.
Good afternoon, Your Excellency, and very much appreciate the break. I have finished my submissions in relation to the alternative service order. Just before I hand over to my colleague, Mr. Jury, to address a matter of jurisdiction, I just wanted to clarify one point that shortly before lunch, Your Excellency referred to Article 7 of the JAL.
Yes.
Article 7 deals with enforcement of DIFC court judgments. So I just wanted to make the point that Article 7 deals with enforcement of judgments. It doesn't deal with service of process, which is obviously what we're dealing with
Actually,
today.
we look at a different point. We look at, even so Dubai court, their interpretation on Article 7, they look at any direction, order, decision come from the IFC court, they consider it under enforcement based on Article 7. So if we have a service order, let's say, or application or request, when we send this request to Dubai court, they consider it as enforcing our request.
Right. Even if it's a request for service. Okay. And obviously in that situation, the primary position is under 9.54 and 9.55 that you're required to try to effect service under the rules applicable in Sharjah, but we're beyond that now because your Lordship, your Excellency has made that didn't work, and Your Excellency subsequently made the alternative service order. But thank you for the clarification. I'll hand over to Mr. Jury, who will address you on the jurisdiction.
Your Excellency, turning back.
Second, yeah.
Your Excellency, turning back to the position of jurisdiction under the JAL, it is the claimant's submission that this court plainly has jurisdiction under Gateway 1A of the JAL, i.e. the Central Establishment Gateway. And of course, that result follows from various DIC Court of Appeal authorities that are binding on this court, including the IGPL case, which Your Excellency would be well and truly familiar with, having sat on that Court of Appeal. The defendant's attempts to distinguish these authorities are fundamentally misconceived and are based on numerous errors of principle. Amongst other things, firstly, jurisdiction is over SCB as the legal entity and not the branch, as has been determined definitively in the IGPL case. Secondly, it is not incumbent upon our client to show an opt-in to the jurisdiction of this court. Rather, it's incumbent upon our opponents to demonstrate a clear and express opt-out of this jurisdiction, which they plainly cannot do. And thirdly, as Your Excellency has already intimated, it is still possible to opt out of the jurisdiction under the amended JAL, despite the amendments in 2011, including the introduction of Article 5A sub 3 of the JAL, and which Your Excellency has pointed out. The whole premise of Article 5A3 is that it is still possible to opt out of the court's jurisdiction, and that point was definitively determined in the Court of Appeal in Karafi, as we'll come on to see. As the respondent is a licensed DIC establishment, the starting point is whether or not there has been a clear agreement to opt out of the jurisdiction of this court. So much was made clear in the IGPL case, and if I can take Your Excellency to our authorities bundle, the teal bundle, at tab 2, page 34, paragraph 137. Now, I think it's worth emphasising this paragraph in full because it does distill a number of the key points. Quote, "Neither are we moved to a different conclusion because the parties' transaction bore no connection to the DIFC. The jurisdiction of the DIC courts covers disputes in which any of the DIC's entities, bodies or licensed establishments is a party, as was held in Corinth." And I pause there to emphasise SCB is, of course, a licensed establishment, and there doesn't seem to be a real dispute about that. It also extends to civil and commercial claims commenced in the DIC courts pursuant to a written agreement between the disputing parties, whether before or after the dispute arises, provided that such agreement is founded on specific, clear and express contractual provisions. In these situations, the DIC courts are not deprived of jurisdiction, even if the claims and underlying facts do not have any connection to the DIFC or do not originate from a contract that has been carried out in whole or in part in the DIFC. Bearing in mind that IGPL transacted with SCB with full knowledge that it was a licensed entity, we take the view that the parties must surely have contemplated the possibility that the DIC courts could assume jurisdiction over any action commenced against either party. In these circumstances, the onus must be on the parties to specifically exclude the DIC court's jurisdiction, if they so intended, by employing express language to that effect. They did not do so. Your Excellency, a number of propositions may be derived from this statement of principle. Firstly, the DIC courts have jurisdiction over disputes in which the DIC's licensed establishments are a party, such as SCB, even if there is no connection between the underlying dispute and the DIFC. In addition, the DIC courts also have jurisdiction if the parties have agreed to submit their dispute to the DIC courts. However, this opt-in jurisdiction is separate and distinct from the DIC court's jurisdiction over licensed establishments such as SCB. Thirdly, in order to avoid the DIC court taking jurisdiction over a dispute involving a licensed establishment, the parties must specifically exclude the jurisdiction of the DIC courts with express language to that effect. That is, it must be shown that the parties have opted out of this court's jurisdiction. In terms of what is required to demonstrate an effective agreement to opt out of the court's jurisdiction, this is dealt with at paragraph 125 of the judgment, which is on page 32. One can see at paragraph 125 that the Court of Appeal here endorses the test from Tulane, and it states, 1, the burden of establishing that the parties had agreed that the DIC courts should not have jurisdiction was on the party so contending, in this case the defendants, and 2, the test to be applied was the ordinary and natural meaning of the words of the jurisdiction agreement as they would have been mutually understood by the parties. And I pause to emphasise that word mutually, having regard to the background circumstances and the nature of the agreement and the context in which the words are used. The defendant's argument that it must be shown that the parties have opted into the DIC court's jurisdiction is therefore plainly misconceived. This can be seen at paragraphs 67 to 70 of the defendant's skeleton, which is in volume 1 of the bundle at tab 19. Paragraphs 67 to 70, which commence on page 138. And in particular, at paragraph 67 of the defendant's skeleton, reference is made to Article 5A sub 2 of the JAL, which of course establishes this court's opt-in jurisdiction, but our client does not rely upon this provision as founding the court's jurisdiction over this claim. Paragraphs 71 to 80 of the defendant's skeleton then proceed on the erroneous premise that SCE needs to demonstrate that the parties have opted into the jurisdiction of this court. As set out in IGPL, that is the wrong test, and therefore the defendant's skeleton argument proceeds on entirely the wrong basis. I'd ask Your Excellency to keep the defendant's skeleton at hand because there are a number of other points that need to be debunked. As our client is a licensed DIC establishment, as I've said, the relevant question is whether or not the parties have opted out of the jurisdiction of this court. If they have not, then this court will have exclusive jurisdiction over the claim pursuant to Gateway A of the JAL. Despite the defendant's attempts to complicate the jurisdictional position, it really is as simple as that. The relevant jurisdiction clauses in this case are extracted at Schedule A to our skeleton, which you can find at tab 20, page 181 of Appeal Volume 1, Application Bundle Volume 1, I beg your pardon.
You refer me to?
Tab 20 of Volume 1 at page 181 of, it's our skeleton argument.
Okay. Your skeleton argument?
Yes.
That's okay.
Schedule A.
Yeah, it's okay.
Thank you. Schedule A sets out the relevant jurisdiction and governing law provisions, and these correlate with the various facility letters and the guarantee that Mr. Abbott has taken you to. As can be seen from the two columns in this table, certain clauses are within the agreements themselves. That's the third column from the left. And in the fourth column, other clauses are incorporated by reference. So some clauses are incorporated by the bank's general terms. But the key point to note from this schedule is that none of the relevant clauses purport to confer exclusive jurisdiction. The facility letters, in respect of the first defendant, confer jurisdiction on, quote, the UAE courts, and the guarantee with the second defendant confers jurisdiction on the civil court of the emirate in which the bank branch is located, which was Dubai. However, as none of these agreements purport to confer exclusive jurisdiction, the parties plainly have not excluded the jurisdiction of the DIC courts by express language, which is what the test in IGPL dictates. Indeed, the defendants themselves acknowledge that the relevant agreements only confer non-exclusive jurisdiction, and so much is plain from paragraph 66 of the defendant's skeleton. Your Excellency, I think it's instructive to compare these jurisdiction clauses with those that were under consideration in the IGPL case. Contrary to the defendant's assertion, the jurisdiction clauses in this case are materially similar to those that were considered in IGPL. And turning back to the judgment in IGPL, the clauses can be found in tab 2 of our authorities bundle, commencing on page 31. And in particular, I beg your pardon, page 35. And in particular, if one looks to paragraph 148 at the bottom of that page, this sets out the jurisdiction clause under the 2009 agreement in that case, which provided that SCB and IGPL agreed to submit jurisdiction to the jurisdiction of, quote, the courts of the UAE. So again, that's very similar to the jurisdiction clause in this claim between the claimant and the first defendant. This, in addition, in paragraph 150, one can see there a jurisdiction clause from a share pledge agreement between SCB and IGPL, and that clause provided for the jurisdiction of the, quote, non-exclusive jurisdiction of the Dubai courts. So again, that's materially similar between as to the guarantee in this claim between the claimant and the second defendant. At paragraph 143 of the judgment in IGPL, which is on page 35, the court made it clear that the meaning of courts of the UAE was intended to cover all courts located within the territory of the UAE, which included all courts within Dubai, which of course includes the DIC courts. Similarly, at paragraph 131, if one turns back to page 33, the court here emphasised that the phrase courts of Dubai or Dubai courts should be construed widely to include the DIC courts. Thus, drawing that to its logical conclusion, at paragraph 154 of the judgment, the court concluded that the parties had not opted out of the court's jurisdiction by these jurisdiction clauses, which are in all material respects similar to those under consideration in this claim. So in my submission, there is absolutely no reason why the jurisdiction clauses in this case should not be interpreted in the same manner as those under consideration in IGPL. Any argument that the ordinary and natural meaning of these clauses was to exclude the jurisdiction of the DIC courts, in my submission, was simply bound to fail. Rather, the plain and natural meaning of these words is that the parties wish to confer jurisdiction on all courts within the UAE or Dubai having jurisdiction. Within the Emirate of Dubai, this included the DIC courts, having regard to SCB's status as a licensed DIC establishment. Any contention that the parties did intend to exclude this court's jurisdiction by conferring non-exclusive jurisdiction on the UAE courts or the Dubai courts would simply be absurd. As noted in paragraph 136 of IGPL, which is on page 34 of the authorities bundle, starting at the second sentence of paragraph 136, with jurisdiction agreements, and in contrast with choosing arbitral seats, parties are free to and often do confer jurisdiction on more than one forum. In the present case, the parties could have intended the phrase Dubai courts to mean 1, only the non-DIC Dubai courts, as IGPL contends, 2, only the DIC courts, or 3, both, as SCB contends. IGPL now seeks to persuade us that the parties have chosen to confer jurisdiction on only one forum, the non-DIC Dubai courts. The question before us, therefore, is this: was there any reason why the parties would wish to deprive themselves of the benefit of one of two closely related and complementary forums in Dubai? And of course, the court then goes on to say, no, that was not the intention of the parties. At paragraphs 71 to 72 of the defendant's skeleton, and also at paragraphs 78 to 80 in respect of the guarantee, the defendants argue that any agreement entered into before 2011 cannot confer jurisdiction on the DIC courts because the so-called opt-in jurisdiction was only introduced into Dubai law by Law Number 16 of 2011, which was issued on the 31st of October 2011. As some of the agreements relevant to this claim predate the 2011 law, which we acknowledge, the defendants therefore say that the parties did not intend to opt into the jurisdiction of the DIC courts in these agreements, as it was simply not possible to do so at the time. Again, these arguments proceed on entirely the wrong premise, Your Excellency, as SCB is not required to show an agreement to opt into the jurisdiction of the DIC courts. Rather, the defendants carry the burden of showing an agreement to opt out by express language, which, for the reasons I've explained, they cannot do. Without prejudice to that position, the defendants' arguments are misconceived in principle in any event. It has been confirmed by the DIC Court of Appeal in Karafi that the amendments to the JAL in 2011, which relate to the jurisdiction of this court, apply with retrospective effect, as jurisdiction is a matter of public order. And this point can be illustrated quite neatly in the Karafi decision at paragraphs 2 to 6. And the Karafi case is at tab 3 of our bundle, our authorities bundle, starting on page 45. One can see from the highlighted text from paragraphs 2 through to 6. In paragraph 3 of the judgment, the 2011 amendments to the JAL it stated that the 2011 amendments to the JAL were introduced before the hearing of the appeal in Karafi. At paragraph 4, the court then notes that it invited submissions from counsel regarding whether or not the appeal should be conducted on the basis of the old JAL, which was in effect at the time relevant to the appeal, or the amended JAL on the basis that it should be given retrospective effect. The court then quotes at paragraph 5 from Article 112 of the UAE Constitution, as well as various USC, Dubai Court of Cassation and English Court judgments. These judgments confirm the following principles. Firstly, legislation is not retrospective under UAE law unless the new order relates to public order or matters of procedure. Second, the distribution of jurisdiction between the UAE courts is indeed a matter of public order under UAE law, and similarly, under English law, procedural laws of this nature are also given retrospective effect. The court then concludes at paragraph 6 that as jurisdiction is a matter of procedure, the appeal was to be determined only by reference to the JAL as amended, and not the previous version of the JAL that was in effect at the relevant time. Applying the reasoning in Karafi, which of course is binding on this court, it therefore follows that the current version of the JAL and Article 5 of the JAL is the only version that is relevant to the disposition of this application. This applies with retrospective effect as it is a procedural law which was confirmed by the DIC Court of Appeal in Karafi. Your Excellency, that puts to rest the defendant's submission that pre-2011 agreements cannot confer jurisdiction on the DIC Court, although that is irrelevant in any event, as SCB does not need to demonstrate an opt-in. Further, as regards the first defendant, the final version of the facility letter in this case was entered into on the 8th of April 2012, which of course was after the amendments to the JAL were implemented. As regards the 2012 facility letters, the defendants go on to contend that this does not constitute an opt-in to the jurisdiction of the DIC courts at paragraphs 73 to 77 of their skeleton. But again, the entire premise of that argument is misconceived. The only authority relied upon by the defendants in this section of their skeleton is the decision of the DIC Court of First Instance in the EBI case. The relevant issue in that case, Your Excellency, was whether or not a jurisdiction clause conferring jurisdiction on the French courts, subject to a unilateral option for proceedings to be brought elsewhere, brought the claim between the claimants and the third defendant within the JAL. And that can be seen in the defendant's legal authorities, tab 13, at page 124. And in particular, paragraph 16 sets out the relevant jurisdiction clause in respect of the French courts and notes that it was subject to an option to bring proceedings elsewhere. Critically in that case, none of the claimants or the third defendant was a licensed DIC establishment, and therefore Gateway A of the JAL was not engaged in EBI. Consequently, of course, because Gateway A was not engaged, it needed to be shown that one of the other gateways or the opt-in was satisfied. That is fundamentally different to the present case, where Gateway A of the JAL is engaged by virtue of SCB's status as a licensed DIC establishment. The decision in EBI is of no assistance to the defendants, as the jurisdictional position in that case was fundamentally different. If anything, Your Lordship, EBI is helpful to SCB in that it confirms that an agreement to confer jurisdiction on another court would not of itself be effective to exclude the jurisdiction of a second court, such as the DIC courts, if that jurisdiction otherwise existed. And that can be seen from the final two sentences of paragraph 14, which state, the jurisdiction clause in the loan agreement in no way governs suing those defendants on those documents, and any surrendering to the jurisdiction of the Nigerian courts was only in relation to the loan agreement. In any event, the agreement to the jurisdiction of the Nigerian courts did not exclude the jurisdiction of another court if that jurisdiction otherwise existed. That's precisely the position we're in here, where SCB is a centre establishment, Gateway 1A is engaged, the DIC courts do have jurisdiction, the jurisdiction clauses are non-exclusive, and therefore they cannot exclude the jurisdiction of this court. In addition to the defendant's misconceived arguments regarding the need to demonstrate an opt-in to the jurisdiction of the DIC courts, at paragraphs 83 to 115 of their skeleton, the defendants make a number of remarkable assertions regarding the scope of Gateway A and the relevance of SCB's status as a licensed DIC establishment. As we will see, this section of their skeleton is based on a number of areas of law and is a rather convoluted attempt to distinguish DIC Court of Appeal authorities that are plainly binding on this court. The defendants argue at paragraph 85 of their skeleton that it cannot have been the intention of the ruler to make it impossible to sue any licensed or registered DIC establishments in the onshore Dubai courts. With respect, this flies in the face of the clear reasoning of the Court of Appeal in Corinth and IGPL. For example, at paragraph 84 of Corinth, which can be found in our authorities bundle at tab 1, on page 11, paragraph 84. Starting from the second last sentence of this paragraph, Justice Sir John Chadwick plainly stated, once it is shown that the party by or against whom the civil or commercial claim is brought is an entity or enterprise licensed, registered or authorised by the DFSA to provide financial services or to conduct any other activities in accordance with the DIC laws, the requirement under paragraph A is met. The jurisdiction exists ad hominem. There is no further transaction-based requirement. The defendants then wrongly assert in paragraph 87 and 88 of their skeleton that the effect of SCB's position would be to make it, quote, impossible to ever sue SCB or other licensed entities in the ordinary Dubai courts, and that DIC licensed entities, conversely, could never sue defendants in the onshore Dubai courts. This is based on the defendant's assertion at paragraph 90 that the parties cannot contract out of the jurisdiction of the DIC court following the amendments to the JAL in 2011. As Your Excellency has pointed out, this is a misinterpretation of the amendments to the JAL. The parties can plainly opt out following the amendments to the 2011 law, and therefore I think that puts paid to our learned friend's suggestion that it is impossible now for SCB to sue another entity in the DIC, in the onshore Dubai courts. Indeed, the parties could expressly confer jurisdiction on the onshore Dubai courts in their contract, expressly exclude the DIC court's jurisdiction. And in those circumstances, the onshore Dubai courts would have jurisdiction in accordance with the JAL. If this point can also be illustrated in Karafi, which I'll briefly take Your Excellency to, turning to our authorities bundle at tab 3, page 65. And if one looks to paragraph 89 of the judgment and following on page 65, it will be plain that this very issue was decided and debated in Karafi. So it is odd that we are here debating the same issue again today. Paragraph 89 quotes from Article 5A3 of the amended JAL, which Your Excellency has pointed out is premised on the ability to opt out of the court's jurisdiction. Paragraph 90 then goes on to refer to Article 13 sub 1 of DIC Law number 10 of 2005, which is the law relating to the application of DIC laws, and it provides that, quote, a submission to the courts of a jurisdiction in a contract shall be effective, end quote. The court then concludes in paragraphs 92 and 93 that the parties may opt out of the jurisdiction of the DIC courts, notwithstanding the amendments to the JAL. These paragraphs state as follows: succinct though this provision may be, its meaning is reasonably clear. The reference to a jurisdiction is clearly to a jurisdiction other than that of the DIC court, and its effectiveness clearly indicates that it can be recognised in those cases where the DIC court would otherwise have jurisdiction. As such, there is no inconsistency between Article 13.1 and anything in Law 16 which would involve Article 13.1 being automatically repealed. It follows that this court can recognise an opt-out agreement, notwithstanding that the exclusive jurisdiction provisions in Article 5A1 would have conferred jurisdiction on the DIC court. So as Your Excellency can see, that's the very point that has been debated today. It has been expressly decided by the DIC Court of Appeal that one can opt out, notwithstanding the amendments to the JAL. And therefore, large swaths, I submit, of the defendant's skeleton argument plainly proceed on the wrong premise. Such a submission is contrary to the Court of Appeal authority, and once this misconception regarding the ability of the parties to opt out of the jurisdiction of the DIC courts is debunked, the defendant's submissions regarding alleged exorbitant jurisdiction carry no weight. It is therefore wrong for the defendants to say that SCD could never sue or be sued in the onshore Dubai courts. Plainly, they could do so if they entered into an express contractual arrangement to that effect, which expressly excluded this court's jurisdiction. The fact that jurisdiction of the DIC court under Gateway A necessarily results in a reduction of the jurisdiction of the Dubai courts was also recognised by the DIC Court of Appeal in Corinth and held to be irrelevant. If one turns to Corinth behind tab 1 of our authorities bundle at page 9, and in particular paragraph 70, it states as follows: it is true that the effect of this decision is that cases which would otherwise have been heard in the Dubai courts will now be heard in the DIC courts, but this has always been the potential consequence of the setting up of the DIC courts, because every conferment of exclusive jurisdiction on the DIC courts in Dubai necessarily means a reduction of jurisdiction of the Dubai courts to that extent. This decision has simply clarified the extent of the jurisdiction of the DIC courts and has not expanded its nature. The defendants also seek to argue at paragraph 89 of their skeleton that this interpretation of Gateway A would somehow have worldwide implications. And in particular, my learned friend this morning has given the example of the Chinese entity contracting with the DIC entity and being dragged into the court's jurisdiction despite there being no other nexus than one of the parties being registered for the purposes of Gateway 1A. This submission fails to recognise that the DIC court's jurisdiction is only exclusive under the JAL vis-à-vis the Dubai courts, and not as regards any foreign court. Secondly, as the defendants themselves acknowledge, the jurisdiction of the DIC courts is subject to the doctrine of forum non-conveniens, where there is a foreign court that is clearly more appropriate for the hearing of the claim. So the answer to the Chinese hypothetical is that if the Chinese courts were clearly more appropriate than the DIC courts, well then the DIC courts would stay their jurisdiction to hear that claim. The defendants argue at paragraph 94 of their skeleton that the decision in Corinth should be distinguished because it was decided before the amendments to the JAL in 2011 and before the DIC court determined that forum non-conveniens does not apply within the UAE. I have already explained why the amendments to the JAL are irrelevant. First, the DIC court retains an opt-out jurisdiction, and that is the key point that the defendants rely upon to argue that Gateway A should now be interpreted differently. As confirmed by the DIC Court of Appeal in Karafi, that point is entirely without substance. As regards the doctrine of forum non-conveniens not applying within the UAE, the Court of Appeal in Corinth expressly left open the question of whether or not the doctrine ought to apply within the UAE, as Mr. Barrett has pointed out. However, there was no suggestion in Corinth that the determination of this question would have any impact on the court's interpretation of Gateway A. In any event, the DIC Court of Appeal in IGPL dismissed this very argument and held that the absence of forum non-convenience within the UAE had no impact on the proper interpretation of Gateway A, and this can be illustrated in the decision at tab 2. On page 30, and in particular paragraph 109. And if one looks to the underlined text in paragraph 109, it states as follows. In Corinth, at 67, it was held that there would not be an exercise of exorbitant jurisdiction by the DIC courts over banks outside the DIC, because that universal jurisdiction over foreign banks with an unincorporated branch in the DIC would be subject to the doctrine of forum non-convenience. We think that the point made is a broad one. That is, so long as some mechanism exists to curtail the inappropriate exercise of jurisdiction, the DIC courts would not exercise exorbitant jurisdiction in the manner complained of by IGPL. Accordingly, the fact that there may be particular cases where the doctrine of FNC is inapplicable is not by itself a justification for departing from the definition of licensed DIC establishment adopted in Corinth, if an alternative mechanism exists to perform a similar function as the FNC doctrine. As we shall explain below, such cases arise when the alternative forum are all courts of the UAE, in which case the UAE Constitution provides a different solution in place of the FNC doctrine by empowering the USC to resolve jurisdictional conflicts between competing courts. So again, it's plain that we're here today debating issues that have been definitively resolved by the DIC Court of Appeal. Gateway A should not be interpreted more narrowly simply because FNC does not apply within the UAE. There is an alternative circuit breaker in those cases, namely the Union Supreme Court, and within Dubai, as Your Excellency has adverted, the Joint Judicial Committee, which was established by Decree 19 to resolve conflicts between the Dubai courts and the DIC courts. In my submission, it's not appropriate for the DIC court to preempt this process by interpreting its jurisdiction more narrowly, as that would effectively deprive these mechanisms of the power that they're designed to effect, namely to resolve alleged conflicts of jurisdiction. In paragraph 101 of the defendant's skeleton, the defendants seek to contend that IGPL was wrongly decided because counsel in that case did not bring amendments to the JAL in 2011 to the court's attention. In my submission, this is a contrivance in an effort to avoid the binding effect of the IGPL decision. It is not open for this court to decide whether or not IGPL was wrongly decided based on an alleged failure to bring these amendments to the attention of the court. Only the Court of Appeal is capable of overturning its previous decisions. This court is bound to apply the decision in IGPL, which leads to the inevitable conclusion that this court has jurisdiction under Gateway A. Without prejudice to that position, that this court is bound by IGPL, it is denied that the Court of Appeal was unaware of the amendments to the JAL in reaching its decision in any event. And in particular, if one turns back to the IGPL decision in tab 2, at page 25 to 26, from paragraphs 83 onwards, the legislative framework underpinning the DIC and the DIC courts was set out in quite some detail in this judgment. And as Your Excellency will no doubt recall, the parties provided extensive submissions about the history of the DIC, its federal imprimatur under federal legislation, as well as the various pieces of Dubai and DIC law conferring jurisdiction. But relevantly for our purposes, if one looks to paragraph 87, there is here a full quotation of Article 5A as amended by the JAL in 2011. Plainly, the court was aware of the amendments made to the JAL in 2011 as they're quoted in the judgment. However, neither party sought to take issue with these amendments precisely because they have no impact on the interpretation of Gateway A. The defendants note in paragraph 107 of their skeleton that the Court of Appeal in IGPL relied on the decision in Tulane, and they say that that was erroneous because Tulane was decided under the old version of the JAL. As I've explained, the amendments to the JAL did not remove the ability to opt out, as was confirmed in Karafi, and therefore the Court of Appeal did not fall into error by placing reliance upon Tulane. In paragraphs 108 to 113 of the defendant's skeleton, the defendants contend that the mechanism for resolving conflicts of jurisdiction by the USC is inefficient and it would be too costly in Mr. Barrett's submission, as it requires two conflicting judgments before a conflict arises. The defendants originally, in their first skeleton argument, incorrectly asserted that there were no parallel proceedings in the onshore UA courts concerning these loans. However, I understand that my learned friends weren't aware of those proceedings until we brought it to their attention. This misstatement has now been corrected, and evidently the defendants have brought parallel proceedings in the onshore Dubai courts in respect of these loans. Any alleged conflict between these proceedings in the DIC and those proceedings brought by our learned friends in the onshore Dubai courts would fall to be determined by the Joint Judicial Committee as established by Decree 19 and not by the USC. Therefore, the remarks regarding the timing of the USC process are entirely irrelevant. In addition, at paragraph 115 of the defendant's skeleton, the defendants make what I say is a quite astounding assertion that only the applicable branch of SCB is a licensed DIC establishment for the purposes of the JAL. That proposition, as Your Excellency is aware, has been repeatedly rejected by the DIC Court of Appeal in both Corinth and IGPL, and I need not, I assume, take Your Excellency to those propositions. Turning next finally to paragraphs 116 to 122 of the defendant's skeleton, the defendants assert in the alternative that the parties have opted out of the jurisdiction of the DIC courts. Firstly, that's entirely inconsistent with their primary position that it is not permissible to opt out under the amended JAL, but plainly that was based on an erroneous assumption of law. And secondly, this submission is misconceived in any event, as none of the jurisdiction clauses constitute a clear and expressed opt-out of the court's jurisdiction for the reasons that I have explained. Mr. Farhad's submission this morning that the domicile of the defendant is somehow relevant to the jurisdiction of the DIC court because of the domicile principle enshrined in Article 31 of the Civil Procedure Law has also been dispelled by this court. And in particular, one will see that in the IGPL decision in tab 2, page 28. At paragraphs 98 and 99, this very point is dealt with and dismissed. And just reading the conclusion in paragraph 99, we therefore endorse Your Excellency's decision in X1 and X2 and Y that the CPC does not apply in the DIC and that the DIC court's jurisdiction is determined solely by the judicial authority law. Having so decided, we do not think it is necessary for us to resolve the parties' dispute over which provisions of the CPC establish each emirate jurisdictional limits. So again, we're here today debating issues that have been definitively resolved, and in my submission, the defendant's position on Gateway A was always bound to fail as it flies in the face of established DIC authority. Having explained the position on Gateway A and why it's fundamentally misconceived, I will turn just very briefly to our two alternative submissions. Firstly, that Gateway B is engaged because the agreements were partly concluded, finalised or performed in the DIC. And secondly, that the defendants have conceded to the jurisdiction of the DIC courts. As regards Gateway B, our arguments are summarised at paragraphs 18 to 25 of our skeleton, which I'll ask Your Excellency to turn to. As one can see from these sections of our skeleton, we placed reliance on the decision of the DIC Court of Appeal in Karafi, and in particular, the very broad interpretation of Gateway B that was adopted in Karafi, which can be seen in paragraph 20 of our skeleton on page 162. And in particular, the final sentence, the DIC Court of Appeal, and then over the page, helpfully summarise that, quote, the essence of the provision is that the court is given jurisdiction where there has been relevant activity with regard to the contract or related to it within the DIC. As noted in paragraph 21 of our skeleton, the first defendant in Karafi, which was based in the DIC, provided various documents, information and advice in respect of certain investments to be issued by the second defendant, which was based in Switzerland, to the claimants who were residents of Kuwait. The first defendant in the DIC also received certain contractual documents from the claimants in the DIC. It was held by the DIC Court of Appeal that this was sufficient to mean that the contract was at least partly, if not wholly, concluded from the DIC, notwithstanding that the claimants were based in Kuwait, and there were some meetings where the claimants were in London, but at no time were the claimants, as I understand the judgment, also in the DIC at the same time as these contractual mechanisms were being carried out. In reaching this conclusion, the court emphasised that it is important not to construe the gateways in Article 5A of the JEL too literally. And I'll briefly take Your Excellency to that point in Karafi at tab 3 of our authorities bundle at page 60. Paragraph 58. It makes the point, which I think Your Excellency has illustrated neatly for us today, by reference to Article 5A3 of the JEL and the Arabic version of that. It makes the point that, of course, the original of the JEL is in Arabic, and therefore we should be reluctant to adopt too much of a, quote, literalist construction of the English to lose sight of the legislative purpose underlying the text. And of course, in paragraph 60 of this judgment, which I've just quoted, the court then went on to say the relevant purpose of Gateway B is to ensure that if some relevant activity in respect of the contract occurs here, then the court ought to take jurisdiction in respect of it. So taking that test and turning it to the facts of this case, we maintain that firstly, the facility letters with the first defendant have been at least partly concluded from the DIC, and the evidence of Mr. Swami in that regard is that they were signed from the DIC by SCB. And I'll take you to that because Mr. Barrett took you to this previously, but not to this section of the statement. If you turn to volume 3 of the bundle, at tab 15, page A523.
Page 5?
A523. And in particular, paragraph 12, which Mr. Barrett has taken you to, but he did not go so far as to take you to the second part of the paragraph, which commences, indeed, the facility letter was signed in the DIC by Mr. Speed, who, as set out in the affidavit and confirmed in the signature block of the facility letter, was the head of GSAM and was therefore individually based within the respondent's DIC office. So in my submission, that's sufficient to engage Gateway B in respect of the facility letters with the first defendant. Clearly they were partly concluded in the DIC if one of the counterparties to the agreement signed it here. Secondly, our alternative point on this is that the agreements were at least partly performed here because certain functions under those agreements were carried out in the DIC. And in particular, I would like to point out, going back to our skeleton argument, at paragraph 22, we here set out the various bases on which we say performance has occurred at least in part from the DIC, together with references to Mr. Swami's evidence. Relevantly, I would draw your attention to the fact that the bank has issued its demand letters from the DIFC, and those demand letters were issued pursuant to the terms of the facilities, namely Clause 1.3 sub E of the Master Credit Terms, which I need not take you to, but is at Application Volume 2, Tab A4, page A226 for the record. Those terms entitled the bank to demand repayment, and of course the amounts outstanding became repayable at that point on our case. And I say it is evident on the face of the demands themselves, which refer to SCB's DIFC address, that these were issued and therefore rights under the facilities were exercised from the DIFC. And one can find the demands in Volume 3, if we go back to that. Tab 14 of Volume 3. At page A472. So here we have a demand issued by Standard Chartered Bank to FAL, and if one looks to the footer, it says Standard Chartered Bank Group Special Assets Management, Dubai International Financial Centre. And again, in this demand, in paragraph 4, there's reference to the relevant contractual terms under which this demand is issued. So in my submission, the parties have at least performed partly the rights under the agreement from the DIFC. Gateway B does not talk in terms of the performance of obligations. It talks broadly in terms of the performance of the agreement. And in my submission, our learned friends are incorrectly simply focusing on the obligations and not paying attention to the rights of SCB, which have been exercised from this jurisdiction. And whilst we're in this part of the bundle, one can see at A476, there's a demand on very similar terms issued to the first defendant, IGPL, I beg your pardon, the second defendant. And again, it has the DIC address in the footer. So this is issued pursuant to the guarantee. And I'm somewhat preempting my next submission here, but the guarantee was also partly performed in the DIFC in circumstances where demands issued under the auspices of the guarantee emanated from the DIFC. And again, one can see that this is it's a contractual notice issued pursuant to the terms of the guarantee, which are summarised in paragraph 1. Whilst we're in this bundle, if one could now turn to tab 16, page A533. What can be seen here is a confirmation letter issued by the second defendant, the guarantor, to the claimant, Standard Chartered Bank, and it is addressed to the DIFC. Now, I accept this postdates the entry into the guarantee. However, it's evidence, again, that certain rights and obligations are being performed or at least have a nexus with the DIFC. Those are my submissions on Gateway B, Your Excellency. And just turning very briefly to our final position that the defendants have conceded the jurisdiction. This point is made in paragraphs 26 to 28 of our skeleton argument. And it is our alternative position that the defendants have conceded the jurisdiction by mounting a substantive defence as part of their application to set aside the default judgments. We readily accept, of course, that a set-aside application of itself does not amount to a submission to jurisdiction. But the key point is that the set-aside application needs to be quite cautiously worded, to use the words from Newland Shipping. And by that I mean the defendant should not go too far into the substance of the case and the merits of the case in order to avoid the risk of a finding that they have submitted to the jurisdiction. In addition, I'd make the point that this morning the defendants have sought to invoke the powers of this court by asking the court to make certain orders in respect of the onshore enforcement proceedings. Plainly, to ask this court to make orders over the parties is a tacit, in circumstances where those orders aren't contesting jurisdiction. They're asking this court to exercise its powers affirmatively. Plainly, that is a concession to the jurisdiction. But turning back to Newland Shipping, which is quoted in paragraph 26 of our skeleton, the points in Newland have been read by our learned friends, and as I said, we do accept that not every set-aside application will constitute a submission, but there needs to be a very great degree of caution by the party who is challenging jurisdiction or seeking to set aside, because there is a risk, if the application is not quite cautiously worded, that it could constitute a submission to jurisdiction. In this case, the defendants decided to seek to set aside the default judgments without, in my submission, appropriately caveating that application. In particular, if one turns to the set-aside application, which is in Volume 1 of the bundle at tab 10, Volume 1, tab 10, page 54. A heading can be seen here, substantive defence, which in itself rings alarm bells from a submission to jurisdiction point of view. The application then goes on from paragraphs 29 to 34 and engages on the merits of the case. And in particular, paragraph 33, which refers to various pieces of witness statement that were filed in support of the application. And in that paragraph, it's denied that the amounts claimed were owing. And it goes further than that. It asserts that there appear to have been various repayments in the course of the relationship. So in my submission, that's clear engagement on the merits of the claim. We also, I should point out, rely upon an alleged concession made by the first defendant in the onshore Sharjah courts and the Dubai courts. The first defendant says that this concession was limited to the jurisdiction of this court to determine the set-aside application. However, the literal wording of the concession is arguably not so limited. And one can find that concession in the application bundle at tab 13, volume 1. Page 81. And it's the final paragraph commencing whereas plaintiff bank appellee demanded validity of provisional attachment, which relates to award judgment to the bank of their claimed right, the judgment still preliminary judgment by default, appealable or could be considered, all of which do not fall within jurisdiction of the esteemed court, that being the Dubai courts, when, quote, DIC courts awarded jurisdiction to consider the dispute between the parties. Of course, Your Excellency can review the Arabic which is included to form a view on the breadth of that expression and its context, but it is our client's position that this was a general submission to the jurisdiction of the DIC courts in respect of, quote, the dispute between the parties. It was not expressed to be without prejudice to the first defendant's alleged jurisdiction challenge, and nor should it be treated as such. And I should just add for completeness, the application to set aside the default judgment was also not expressed to be without prejudice to any jurisdiction application, particularly to the extent that application did engage on the merits of this claim. And unless Your Excellency has further questions for myself or Mr. Abbott, those are the respondent's submissions.
Thank you.
Your Excellency.
Mr. Willis.
Yes, I have a number of points I'll keep it short if I can in reply. I thought it might assist Your Excellency in court if I address the jurisdictional questions first. That, of course, is a freshest in everyone's mind, but addressed by Mr. Drury. The first point, Your Excellency, is that Mr. Drury relies on the case of Karafi and saying this sorts to show that the 2011 amendments to the bylaw 12 of 2004 have retrospective effect. We do not dispute that. However, that retrospectivity notwithstanding, that is not capable of changing what the parties at the time, prior to those amendments, must have intended. So therefore, as a matter of simple logic, it's not possible for a party prior to 2011 to have intended to have agreed to changes that were not yet promulgated. The fact that the legislation may have changed and has a retrospective effect is not in dispute. What's in dispute is the question of what the parties objectively agreed. So I think that's my point on that. Similarly, Your Excellency, second point in relation to Karafi, Mr. Drury says that the amended law 12 of 2004 does, he says, in fact, permit an opt-out. And if one looks, in fact, very briefly, Your Excellency, at the decision, which is at the claimant's legal authorities, tab 3, claimant's legal authorities, tab 3, and it's the same page Your Excellency looked at before, which is page 65. Paragraph 9, page 65. The court there explains, it's to be observed that this does not provide in terms, referring to Article 503, for parties whose dispute would otherwise fall within the exclusive jurisdiction of the DIFC court to submit their disputes to the jurisdiction of a foreign court. This has been expressly provided for in Article 5A2 of Law 12 and is not repeated in Law 16. However, Article 5A3 of Law 16 makes no sense as the underlying right to contract out of the exclusive jurisdiction of the DIFC court. One or both of the parties must be presumed not to have invoked DIFC jurisdiction and to have gone straight to a foreign court in reliance on a foreign jurisdiction agreement. So the references there 3 times, Your Excellency, to foreign. Foreign in the sense of this, what the court, we say, was saying there is that as between the allocation of jurisdiction between the DIFC courts and a foreign in the sense of non-UAE courts, then this is the approach to be adopted. And that, we say, must make sense as a proper interpretation, because otherwise it would potentially fall foul of the example my learned friend Mr. Farhad gave in relation to a Chinese customer. But if we take Mr. Farhad's analogy, and with the greatest respect, if we make it a little bit narrower, and instead referring to a Chinese customer, instead refer to a customer in another emirate, like of the United Arab Emirates, in those circumstances, that still squares entirely with the reasoning in Karafi, and the analogy still applies. And we say that that's what the court is referencing there by clearly talking about a foreign court, and that this addresses foreign parties, Your Excellency, can be seen simply by reading over the page, page 66, at 94 and 95, was a discussion there of Switzerland. So we're not discussing here intra-UAE jurisdictional disputes, we're discussing foreign disputes. Moving therefore, Your Excellency, to the next point, Mr. Drury also said that Corinth left open the question as to whether forum non-convenience exists. Now, with respect, Your Excellency, we say that's not so. Rather, it simply left open the question as between the DIFC courts and the Dubai courts. And that can be seen, again, very briefly, Your Excellency, at Defendants' Legal Authorities, tab 12, which I will briefly turn to. Defendants' Legal Authorities, tab 12, which is the decision itself in Corinth, page 116. So we'll just go to. It's the same paragraph which both I and Mr. Drury separately took to, paragraph 68, in particular 68C, where the court says, the situation under consideration will clearly not arise where the central establishment is a company incorporated and carrying on business in the UAE outside the Emirate of Dubai or elsewhere. The principles of private international law limit the powers of discretion of the DIFC courts so as to prevent the exercise of exorbitant jurisdiction. and the DIFC courts possess the discretion to decline jurisdiction on grounds of forum non-convenience. Now, the point, and if one then goes to paragraph 69, Your Excellency, this is the pertinent point, I leave open the question of the applicability of forum non-convenience in a case which is prima facie within the jurisdiction of both the Dubai courts as well as the DIFC courts by virtue of Article 5A1, as neither party has before this court addressed us as to whether that doctrine should apply to the facts and circumstances of the present case. Accordingly, the obiter dicta of the Deputy Chief Justice on this point, paragraph 56 of the first instance judgment, remains for consideration by a future court. So what the court in Corinth left open was not the principle as to whether or not forum non-convenience applies, which we know it does not because of alliance. It simply left over the issue between the Dubai courts and the DIFC courts. Of course, here we're dealing, certainly in the case of foul oil, with a party domiciled in Sharjah. So I say, therefore, the two observations, Your Excellency, I made earlier, the two pillars which I said support the edifice of IGPL and Corinth are no longer there. Turning, Your Excellency, therefore, to a subsequent point, fourth point, the claimant's interpretation would, I would suggest, be exorbitant. We do not dispute that the question is to be decided by reference to Law 12/2004. The question in all of this is in essence how that law should be interpreted. And it's not a question of seeking me to persuade Your Excellency to try to go behind what the Court of Appeals decided, or to decide something contrary to the manner in which Law 12 as amended has been drafted by the ruler. It's a question of giving a construction or an interpretation which makes sense and which is consistent with general principles Mr. Farhad outlined. Your Excellency, my fifth very brief point before moving on to the order for alternative service is Mr. Drury took you to Mr. Swami's witness statement. I need not take you again at bundle 3 for the reference, tab 15, page A520, where he referred to the second part of paragraph 12. Your Excellency will recall I took you to the first part, where he said that the facility letter, quote unquote, was signed in the DIFC. Now, Your Excellency will recall from our discussion this morning, from the start of paragraph 12 and earlier on in that witness statement, and I can take Your Excellency if need be, that relates only to the 2012 facility letter. So we're not discussing earlier facility letters in that witness statement. So at best, what the claimant has is an argument in relation to an agreement entered into in the DIFC in relation to that one facility letter and in relation to that one defendant, foul oil, not more broadly, which of course predates 2011. Your Excellency, very, very briefly, before I move on, right at the end of the submissions, Mr. Drury referred you to the Newlands case, which Your Excellency will recall I addressed you on this morning. Now, the Newlands case, as I explained, was not a case where the English court was saying that in looking at an application to set aside default judgment, one must be cautious. That's not what the English court was saying, as Your Excellency will recall. It was explaining why the decision of the respondent or the applicant in that particular case not to challenge default judgment alongside challenging jurisdiction was not, in those circumstances, an unreasonable one. It's not laying down a general rubric. It was explaining why that was justified in those facts. In relation to this matter, we say our set-aside application, at which Mr. Drury took you to, clearly related primarily and in substance to questions of jurisdiction. It addressed issues of service, it addressed issues of jurisdiction, it also sought to expressly reserve rights. To the extent that there was any dispute, Your Excellency, as to the extent there was any engagement on the dispute, it was a dispute as to the validity of service, not a dispute as to the fundamental merits of the claim. So if one looks at the document as a whole, which one must do, we say it's clear it was reserving rights in relation to jurisdiction, and instead it was focused primarily on jurisdictional grounds of service. So I will therefore turn very briefly to the issues addressed by Mr. Abbott in relation to seeking to set aside the order for alternative service. At the very outset of his submissions, Mr. Abbott said that in the set-aside order granted by this court on the 11th of February, the court had confirmed that the claim form had in fact been served. He referred to the set-aside order itself, which for Your Excellency's records is at tab 15, page 91 of the hearing bundle. He said that the claim form was served at the email addresses. Well, Your Excellency, the point here is not whether the claim form was or was not sent to those email addresses with respect. The question is whether the order for alternative service was properly made in accordance with RD 23.93 and in accordance with the applicable provisions which permit an order for alternative service to be made, i.e. namely, was there evidence of difficulties in terms of service, and indeed was there a good reason to make the order? So in essence, Your Excellency, what I'm saying is that even though the service was affected under the order for alternative service, it's dependent upon the validity of that order, and that's what we're challenging here today. Your Excellency, the second point in relation to Mr. Abbott's submissions relates to Denton, briefly. Mr. Abbott suggested that the approach adopted by our clients is an opportunistic one, he said, and that we should instead, in essence, we ought to have agreed to his request for relief for sanctions. Well, putting aside the fact, Your Excellency, that first we knew of his request for relief for sanctions was a sterling argument, so we weren't invited to agree to anything. As a matter of principle, this is entirely wrong. Failing to comply with a mandatory provision, as I've outlined in RDC, two mandatory provisions, outlined in this RDC 23.93, is not a mere procedural error. It's the entire basis with respect to this court's jurisdiction. Discouraging opportunism in procedural matters is an important part of the court's role in giving effect to the overriding objective. It's dealing with minor, technical, highly technical disputes, questions over extensions of time, issues over technical formality of court documents, not with foundational documents, Your Excellency, on which the whole basis of the service of the originating process, not of other documents, is addressed. So I would respectfully submit, Your Excellency, that the right approach here is that this is a matter which must properly be set aside. The other issue raised by Mr. Abbott is that the approach, and you referred to Dardarian in the White Book reference to 23.10, he suggested that the approach of setting this aside ought to really be limited to questions such as freezing orders. Well, Your Excellency, that's not so. 23.94, as Your Excellency knows, provides in very clear terms that any party who is not served with a copy of an application before the application was heard and determined has a right, as a matter of natural justice, to apply for the court to consider that matter afresh, which must be right. It's the quid pro quo, if you will, of the court's power to consider applications ex parte. It's the right of the other party to come to the court and ask the court to reconsider it. It's essential, therefore, we would submit that applicants of these types of orders who bear the risk that was identified in the White Book commentary must comply in terms, and very carefully indeed, with the court's requirements, and can't simply omit fundamental requirements of natural justice. Your Excellency, when dealing therefore with good reason, which is another limb which Mr. Abbott addressed, was there a good reason for this court respectfully to have granted the order for alternative service? We say, Mr. Abbott says that the claimant did not need to have provided evidence of a step taken to serve the claim form in charge. This, with respect, is wrong. If I can, it's the last authority I'll take, Your Excellency, to. If we could look at claimant's legal authorities, tab 23, which may be in the second bundle. Claimant's legal authorities, Your Excellency, tab 23, page 465. We're half the way through it. And Your Excellency will see there at 9.31 and 9.32, 9.31, where it appears to the court that there is a good reason to authorise service by a method not permitted by these rules, the court may make an order permitting service by an alternative method. And then Your Excellency, 9.32, an application for an order permitting service by an alternative method must be supported by evidence stating A, the reason for an order for an alternative method of service of sort, and B, what steps have been taken to serve by other permitted means. Now, you see the point we're making here is that Mr. Abbott took you to the attempts that the claimants did make to serve it. He referred to DHL, he referred to process servers, but there was no application made to the local courts to seek an inquiry as to the address of the defendants. There was no notification, Your Excellency, in the press, which is well known as an ordinary method in which to draw this to the courts to the defendant's attention. So the point, in essence, is that the claimant does not draw, with respect to this court and to Your Excellency's attention, the steps it took, or ought to have taken, to seek to comply with those requirements set out. So, Your Excellency, those are essentially the points I would make. The only additional observation I would briefly make, Your Excellency, is in response to the court's statement, quite proper statement if I may respectfully say, that this court may not interfere with the process in Sharjah. That's, of course, entirely accurate. The point I think I'm trying to make, Your Excellency, is that the court is entitled, indeed we would say required, to ensure and to take into account what steps were taken by the claimants to seek to serve in Sharjah, and therefore to consider whether or not there was a good reason, quote unquote, or otherwise, to make the order for alternative service. And so, Your Excellency, the point we would say is that there was no good reason in these circumstances because the claimant regrettably did not draw those matters to the court's attention. Your Excellency, I can assist you further.
Thank you. And the remaining is the cost, which after I'm dealing with the preliminary issue, which is the jurisdiction and the alternative service application, I'm going to consider the cost and I'll give an opportunity to the parties to do written submission. I'm going to reserve the case for judgment. I'll try to finish it before end of Ramadan. Unless if you want to say something or submit any further submission.
No, Your Excellency. No, Your Excellency.
Thank you.
All right.